construction disputes.
Hello.
Yes, sir.
Good morning. Am I audible?
Yes.
Okay. Very good morning. I think there is some problem. I can't hear clearly from there. Kindly let me know if any problem in the hearing. Honorable Mr. Justice C.S. Dias, Judge, High Court of Kerala and Member Board of Governor of case MCC. Ms. Jubia, Learned District Judge and Director case MCC. Other honorable dignitaries. Am I audible?
Yes, you're audible. You're audible.
Yes, sir.
Thank you, ma'am. Very good morning to all, and I am honored and privileged to given this honor to speak before such a learned gathering. Specifically, I am thankful to Ms. Jubia, Learned District Judge, for inviting me for this. Now, being primarily an arbitration professional for a long period and done a lot more arbitration, how do we think about mediation for resolution of dispute in construction sector? So I will have my honest opinion and see the scope of it. Now, let us first understand that in major chunk of arbitration in India, maybe 50–60%, though I don't have a concrete data, is related to construction disputes. And out of the same, the main mechanism now adopted is arbitration. Whereas there are some PSUs which have deleted arbitration clause or restricted arbitration clause. So we have a situation where mediation can be used in 3–4 stages. If there is no arbitration, mediation can be used. If there is an arbitration clause, still mediation can be used, and Section 30 of the Arbitration Conciliation Act provides for mediation. Now there is no dispute resolution clause, then even under Section 89 of CPC, it can be referred to mediation. So there is a wider scope of mediation in construction disputes, but it has not been used effectively or to the desired level so far, particularly in the government and when our PSUs are involved. So in private parties do settle many issues through negotiation or mediation. Now, looking at a mechanism vis-a-vis arbitration, if we see a wider scope of mediation, how and when it should work. Now, we have to primarily understand the nature and type of disputes in construction sector. Now, one set of disputes which arise, these are due to interpretation of contract or some ambiguity in the contract, the operational problems in the contract, or technical complexities in the contract, etc., which involve some technicalities or understanding of the contracts and its operation. The second group of disputes that arise primarily, which are delay damages, etc., which involves also complex application of the legal principles. So both type of disputes happen, and probably it may not be possible to compartmentalize always the disputes. So there may be issues where the technical and legal issues will be intermingled. Now, if mediation to be utilized or used for such disputes, then the traditional approach of mediation, which is primarily facilitative, might not work. The reason being is that in commercial or construction contracts, the claims are primarily money claims. And when there are money claims, there is an issue of both admissibility as well as quantification. So there has to be little more objective analysis of the claims. Now, the evaluative mediation may be more useful in such type of disputes. Now, when we talk about facilitative mediation, it is primarily the mediator brings the parties on the table and they are supposed to negotiate and then settle the disputes among themselves. But now there are differing perspectives of the parties on interpretation of contract, or they may have different perceptions about the outcome which might be in arbitration or in court litigation. Now, a credible mediator who understands the underlying interests of the parties, understands the facts of the case, the technical complexities as well as the legal issues, may suggest solutions to the parties or may indicate to the parties without appearing to be biased or losing its neutrality, maybe individually to the parties, where the parties are educated or suggested, and there can be a possibility of their change of perception about the outcome. Now that may drive to the parties to mediate and settle. Now, what are the two distinct advantages for mediation in this case? Now, mediation can be less time consuming and can be invoked multiple times in a contract. Whereas arbitration, though theoretically there can be multiple arbitration in a project or in a contract, now it has its own time span. By the time the resolution happens, the projects might be derailed or project may be over, and the further there are problems of enforcement of the award. And so arbitration is, as we understand now, is the beginning of litigation. Whereas in a mediation, the control remains with the parties. The outcome is also controlled by the parties, unlike in arbitration. And there can be a reasonable win-win settlement between the parties. The contractor may settle if it gets the amount now at a much lesser amount than what is will be the outcome in arbitration with the delay and the interest claims, etc. And so far the employer is also concerned, then at the end it pays much higher, and the interest of the project is not preserved. Now the major problem today in mediation, what I understand, is the decision-making process by the government and PSUs, whether they accept mediation and whether they accept mediation and the settlement process, because they have to take a decision. So I have two suggestions if mediation is to be made effective. Now, of course, government has now introduced the mediation bill. I understand it is passed in the Rajya Sabha, and the scope of mediation is being widened. And we are talking about institutional mediation and all that. But unless the users use it and we have effective institutional mediation, then because we need the mediator should be someone who is so credible, where parties trust, and both for its neutrality and its understanding of the case. And second requirement is this: the government or PSU also should have some institutional mechanism to take a decision, so that the present element of fear of vigilance and audit, which is a great hurdle for decision making and settlement in mediation, because it can be driven to the government sector also. If they settle in a mediation, then it can be done at a much lesser amount. Now, still one part I personally feel like many times in the arbitration or pre-arbitration process, some contractual claims are settled. Like there may be an issue of admissibility of variation or quantification of variation amount. There may be an issue of whether escalation is to be payable or not payable, or to what extent. So, and maybe there is some issue regarding the scope of the contract and whether certain thing is within the scope or beyond the scope, whether the contractor is liable to do the work within the scope or it goes out of. Now, these type of things are more amenable and easily can be settled and accepted by both the parties if some credible mediator makes an assessment or gives suggestion to the party, and they might accept it uh, in the interest of the project as well as considering the possible outcome. But the second category of claim of damages, today there is a phenomenon of what we call as inflated claims. So the damages claims have now increased manifold and far outweigh the claims of other contractual related claims. If you look into 1980s or 1990s, the claims of damages in construction disputes were much less. Now, when the claims of damages are concerned, there are questions of evidence and other issues come in arbitration or even in a commercial court if it is settled. Now, here the expectation of a contractor to claims of damages getting money as a compensation remains, and whereas the departments or PSUs will be very, very reluctant because the primary issue is of breach. So that will be a tacit acceptance of breach of contract by the employer. And that is the difficult part of it. But if these issues are also reasonability can be drawn, where if the contractors get some compensation, reasonable compensation, much lesser than what they claim, and some credible system or mechanism is set up within the government and PSUs for acceptance of some reasonable compensation for delay. Maybe delay may be for price rise, delay may be for claims, delayed damages claims may be for price rise, maybe for overheads. And so these type of claims, if reasonably decided, if contract does not provide, but under the law, these are permissible. Now, these can also be settled considering a reasonability factor on that. So the today arbitration is also has many issues, and probably still people are struggling with arbitration, though that is considered to be the best alternative mechanism, but it has many, many issues involved. Now, even the commencement of arbitration is a big issue. Okay? It takes huge time to commence arbitration, and there are litigation before arbitration is commenced. And similarly, post arbitration, the cost of arbitration has also become very high. So there, and one problem is there, we in India do not have certain mechanisms like other common law jurisdictions have. Like England has HGCRA, Housing Grants Construction Regeneration Act and Construction Act. And there are Securities of Payment Acts in Singapore, Australia, even Malaysia, and many other common law jurisdictions, where there is a rubric that pay now and litigate later. So there are immediate reliefs. There are emergency arbitration in some other jurisdictions, and in India also it is not barred, but the statute doesn't provide. Now, mediation can provide immediate relief and help the projects. So my suggestion will be to institutionalize mediation in two ways. One is the having the mediator system, where we have credible mediators who are qualified and who understand the construction disputology and also are trained in law and have fair understanding of the law, because it is not possible to deal with construction disputes without a fair and proper understanding of the law. So this compartmentalization is not possible. That somebody is only a technical expert or someone is only a legal expert will not work, because the mediator should be someone who has a broad and good understanding of both the aspects. And second part is that preparing parties for settlement and the government and PSUs, which are dealing with thousands of crores of claims, and looking the advantage of this, because the final amounts of awards and which are finally pending in courts or various levels has become very, very high. So there is definitely a great scope of mediation, but only question is that we should have a credible system of mediation to deal with construction disputes. And for their this type of arrangements to be made. There may be certain disadvantages, and which, like if there is an emergency relief sought, right now, suppose there is an encashment of performance guarantee, etc. So obviously, people rush to Section 9 of the NC Act 1996 to get an injunction, and or unless the tribunal is constituted, and tribunal also has a power, so the injunctive powers are there. Whereas in here in mediation, in one party is hostile, so immediate resolution in a mediation may have certain difficulties. But certain provisions can be amended, like in Section 8 of the NC Act 1996, if there is an arbitration, now parties are referred to arbitration, and now parties can also be referred to mediation, and now many things can be settled in mediation. And though this reference is under Section 89 now of CTC, but now Arbitration Act also has a mandate, and which has not been tried much by the arbitrators under Section 30. So that should be enlarged. Finally, my understanding is that the awareness and the right type of environment is to be created where both the stakeholders find advantage in mediation. We can't sell a product or an idea just based on some theoretical concept. Parties must find interest or advantage in that system working. And so it will work, and it has a great potential because the arbitration has become highly litigative and almost very adversarial in nature. So definitely mediation where relationships are mended, and mediation has the advantage where it primarily addresses the underlying interest of the parties, where arbitration is more dispassionate. Arbitrator cannot decide what is just and fair unless expressly authorized by the parties, whereas in mediation, every issue need not be settled exactly based on the legal rights, and certain issues can be compromised also by the parties. So that will be a better way and more cooperative approach, because various different type of contracts are evolved in other countries, like NEC contracts are being now followed in Hong Kong or in England, where the approach is of cooperation and approach is not of competition or adversarial during the contract management. Now, the moment arbitration started in an ongoing project, parties become adversarial, and it doesn't help the interest of the project. So mediation has the advantage, and I understand with the new mediation bill, it will almost subsume the process of conciliation, and that is what I am suggesting of an evaluative mediation. So that is what I feel, and thank you again for giving me this opportunity for addressing this learned gathering. Thank you very much.
Thank you, sir. Thank you for that enlightening address. We'll be moving on to the next session now. The second session will be on the topic mediation in commercial disputes. May I now request Honorable Mr. Justice S. Sidijagan, former Judge High Court of Kerala and former President and long-term member of Kerala State Mediation and Conciliation Center, to preside over this session. I invite Advocate Anil Savior, mediator and senior trainer, MCPC, to moderate the session. Mr. Sriram Panchu, attorney of the Madras High Court with a standing of 46 years at the bar. Mr. Sriram Panchu was instrumental in setting up India's first court annexed mediation center at Madras High Court and has played a pivotal role in training thousands of mediators. His appointment as mediator in significant public disputes, including the dispute between state of Assam and Nagaland, dispute within Parsi community in Bombay over a ban on peace, and the Ayodhya dispute itself, stand testimony to his acumen as a mediator. I wholeheartedly welcome Mr. Sriram Panchu to this occasion. Mr. Hasib B. Singh, an accomplished arbitrator and mediator in commercial litigation and contracts, He has served as a first-tier counsel in international commercial arbitration for shipping freight dispute, monorail construction dispute, arbitration and private equity arbitration between fund and its managing director. Founder editor of Center for Trial and Arbitration Advocacy Research, Open Access in Dispute Resolution and Inter-Commercial Disputes Report. Mr. Hatip B. Patel has won several accolades, including Mumbai Center for International Arbitration Award for Commercial Dispute in 2023. I wholeheartedly invite Mr. Hatip B. Patel on this occasion. May now request the President of the ceremony, Honorable Mr. Justice S.C.T. Jagan, to address the order ceremony.
This session. The Commission to this was 15 years ago. But at that time, nobody seemed to take this. Anyway, it has taken almost 15 years. True. That is far as already possible. Second is that has been more mediation that the parties who have created allegations and who have come to a really adversarial situation. Whereas if litigation and mediation is instituted, then the beginning of the dispute itself, the mediation process can it's also the commercial disputes. In commercial disputes, should have relations also. And if it comes to a adversary litigation and chance of interaction in discuss English, whereas in pre-mediation in commercial dispute settle, the parties can mark as friends and continue their business. I will and we have also a moderator who mark the mediation much before terms and the same for giving the states to them. I would just like to suggest one thing. People need to start. I was totally disappointed today, morning session, where none of the sitting judges participated. So unhappy because the sitting judges are the most necessary part of the mediation process. In fact, I think all the sitting judges should go to 40. In fact, just like the judicial officers who now undergo 14 hours training in the judicial therefore start take the initiative because they just do not know when to and whom to refer. For example, I have come across 3 cases in which the arbitration court referred, High Court referred cases for mediation of everybody. With absolutely no idea about mediation. Mediation is a structured process. You can bring the mediators and success. Savior, initiate.
I invite Advocate I. Silver, Mediator and Senior Premier, Mediation and Conciliation Project Committee to moderate the session.
We privilege moderating a session. And this is Mr. reminding me. And we congratulate first, this is Mr. and his team. Over. Congratulations with Anju. At the beginning, when this court made a committee to draft and was work the committee. And there were several other committees after that. We were there till last stage, in the sense after the standing committee was made, till the mistakes actually came to the register. And was that act. In fact, even though we are not happy with the act, but it's a beginning, having an act. Coming to this session, 50 disputes. Moderator might give you to put the place so that the speakers can take over the session. Let me take 2 cues session, inaugural session, and I think we suggested that in the private mediation, especially matters. Concept where mediation is supposed to be a process-oriented process, that should be a process expert rather than a subject. Because it's not an adjudication, it's a mediator tries to bring the parties together for a resolution. In fact, we are having the mediation act late. The process has gone much bigger. Now, the concept of a process expert conducting mediation comes to a different stage when the parties expect the mediator not to suggest solution, understand the problem. To understand the problem, especially in a commercial matter and in dispute. Mediator can't be totally ignorant of the content is. He has to know something about the content because he has to understand what the party is talking about. Even though he can't express his opinion, can't suggest a solution, he is facilitating the parties to come this. Parties should not be wasting their time to make the mediator understand the dispute problem. So, unlike a coordinated mediation, the private dispute, the private mediation, the role of the mediator is much practical. We have to understand what type of dispute is coming from. So, I look forward to the panelists to discuss more about what the mediator should be doing in a private. Secondly, I think it's only mediators, because I say about subject excluding the mediator. Simply lawyer alone. Fortunately, unlike the arbitration proceedings, mediator or the mediator panel need not always be an odd number, and even number also. I think in a more successful commercial mediator, the mediator approach, the lawyer and other expert, constitute a good team in a commercial matter or even. So, because there is no question of division of idea. So, because in mediation, nobody is going to give a judgment. Well, mediate the panel does. The next thing is one thing that is pointed out by the association president. And lawyers should be given a more practical role in mediation. That also is a matter to be considered privately. Unlike the court mediation, parties are given more priority and private mediation, the general trend is lawyers will be represented as lawyers. And one of the suggestions that we made actually in practice, mediation conference. So in private mediation, especially when you're doing private, before the parties actually meet the mediator, there should be a system of a pre-mediation. Mediator gets to know about the dispute, that's what the lawyers, and look at the positions of the parties, the law. Because what are their legal, what is hindering the parties to a resolution? What are the positions they are taking? These things have to be understood clearly. The parties come. That positional understanding the parties are doing. It's always a good option for the pre-mediation conference with the lawyers. That's an acceptable practice. And another aspect is openness mediation, the court of mediator lesser. Because once the settlement is made, we go to the settlement back to the court. Court will make the judgment is not. But in a private mediation, court will keep the settlement agreement. It stands the scrutiny of the court by itself. So it should convey the requirement of a post-settlement agreement. That art of writing. There are certain things that we need to understand when you enter into private mediation. And of course, we should act those situations that we come up with. Open explication, mediation rules, mediation, and the grading of the university. Have to get equipped to undertake mediation. With these things, I will move forward more in-depth question on these topics as to how and address a private mediation. I would look forward to Mark rules and Asic's views on this. So maybe after that, we have probably those things. More that the time is running. Start with this.
Mentioned our combined efforts after several policy years targeting parliament. It is actually drafted. The law make the country's laws. But half the country's litigation undoubtedly the cause. So commercial mediation. Commercial mediation is about tangible assets. But it's not just about tangible. There's a lot of intangible stuff, emotional stuff. very often the root of the problem is in an emotional. So we have to be very careful about emotion. I think this is actually right. Focus on privilege. I just want to expand that privilege. Privilege to knowledge. And thereby take into account all the vast tendencies. Now, to avoid the tendency of cases is a burden. To a mediator, the treasure house. Now, what do commercial people want? As I said in the morning, in this time is money. Keep costs low, avoid risk, get a good result, practical result, not a legal verdict. Be able to enforce it. Enforce it seriously. Because the court would not allow the party to go to merits without the challenge of very limited. Let me tell you an interesting thing. I have mediated for 30 years. I have not had one case that a party very rare. Enforcing just about respecting relations. Also what is want. And only mediation is boxes. But our theorizing is not enough. When I stand here and talk, I'm preaching to the choir. You are all converts to mediation. We have to take a message out there to say that mediation actually practically works and has worked in so many cases. That's why Justice I would suggest that, and I'm suggesting these various forums that we actually bring out successful. We camouflage the names of parties and hide the fact, but actually for success stories of how intractable disputes came to be. There is an old saying that says, unsolicited advice. And I'm going to give some. This is born out of the fact that I have, I think, possibly the most experienced more than anybody else in the country starting running. This comes with that background. My advice to the new sentence. Pay well, pay your mediation. Move away from this other areas. Pay well. Because only when you pay well, you expect them to perform. I knew many people are thinking of mediation as a full-time career on this path. They need to do well, they need to earn well, they have to pay well. Pay also for effort. Don't just say it's only if you have successful mediation, you will pay for effort. Even days, pay for that. May not be at the same rate. Pay for that. Have some system by which stock up so many successes before you get paid for. Collect from partners. Of course, you can ask each three parties to pay. But there is another way to. Please understand that in many cases, parties reap huge benefits. Mediation over small passage of time, and it resolves the problems worth tens and hundreds of dollars. They are willing to pay because they are grateful. Now, the first cases I did was in Saturday Motors. One of them was $50. 2006 was very big. We got a settlement between the banks and workers. Banks got 30 crores. Settlement benefited 2,000. After the settlement, we partial by workers to bring in banks. Banks can be in several. So you can't pay, we don't. Because 30 crores. We will not see this money, that's our lives. We need a water cooler in our mediations. Why is water? They want to take to the water cooler and check. People are willing to pay. We set up a system where in the big states, after the mediation is over and there is an excellent result, you have a judge asking parties, I'm sure you're grateful for the result, and what are you willing to pay? And they will be happy to pay. People I have noticed have no problems about paying for mediation services. They feel about paying lawyers because they don't have to pay the courts. So they actually see a benefit. They are participating. They are most willing to pay. Please make pay, not depend on government. We can be self-sustaining. Don't have to depend on government. And outside the mediation, you know, the lawyers can pay a negative. Lawyers are a must. I have found that lawyers usually, not say all, there are cases where lawyers are obstructed. Lawyers usually they are good. Once you get there into it, part of the process in a mediation section of bringing people into it, training, bringing them into it is also by the lawyers. By showing them, look, you have a good role to play. Well for you. Bring the lawyers into it. Keep them there, hold them. I think the time has come where we should reconsider legal fees. Right now, we think of legal fees as a per hearing basis. That disadvantages people who take that advantage. There's a very heavy case when we settle in the matter of fee. Left to litigation, we should recognize that there is a significant distance in the legal community. We stick to this practice. We stick to this practice. Thank you. We stick to the practice. Lawyers only entitled per hearing fees. And if we let instead mediation allow them to move a consolidated settlement. Practice is like what is starting to happen. Let me tell you what happens abroad. Big law firms, appearing court, before they start the mediation, law firm, the head has a discussion. CEO says, look, what does it cost to take me to trial? And the lawyer says 100 million, well, 100. CEO says, fine, get me a good settlement, I'll give. Now just look, this is multi-benefit. The CEO has managed to get rid of their problem by paying 30 instead of paying 100 in trial with an uncertain result. The lawyer has got 30 right from the beginning, are going through 10 years. Everybody's happy. We need to think, money is important. Let's not kid ourselves that money is not important. Money is important. Money made well is good money. We should think of ways where we encourage and lawyers feel we must pay attention. My other point, let's get rid of this mentality that if you're doing good work, you should do it free or charity. Let's get rid of it. I've got judges tell me, oh, mediators, you do such good work, you should be doing it. And what is it? Is a converse that if you're a black marketer or your girlfriend day before you can make lots of money? We should get rid of that mentality. When a mediator delivers professional services at professional quality, lives up to professional expectations, mediator is entitled to professional fees. As simple as. But this also means that mediators must up their efforts. They must deliver best effort, full effort. They must update themselves, learn, they must read, watch, reflect, they must go to mentors, the procedures for co-mediation, and they must constantly improve themselves. That's what a professional.
One of my contributions to Mediation Act rules which I am happy for is I think I managed to do this, that you must make it not every person 3 and 21. Because I have found that keeping the age of 30 or 35 only means youngsters who are interested in you, somebody idealism properly, and they told they can't participate. So they will go away. We don't allow them. So I made it a point to say 21 that we do not lose our youngsters who are interested. And they should be given, I would suggest, just start at this. You should be enable youngsters to come as co-mediators, so that they can learn from senior. Also, my other advice is that once the board refers, as people time spins out, lose track, have a system of which you can track on happening, not happening. I would say you should respect party choice of mediators. Parties are paying twice. I say this with area. I know that in the structures, you can't fully respect party choice because one party, party may just choose the most prominent. So you might like to curtail the numbers of each mediator at any time. But party choice should be there. And if a party says, no, I don't want this person, I think the center must involve subject matter experts. Certainly, I think lawyers who make this. We know about conflict. We know the law. We have to evaluate also the case, assess cases for legal strength, parties. And we are good as resolvers of conflict. We are used to working with people. But not just us, there are others also who could be surveyor, different kinds of people. So we should bring them in. And we should have the capacity to bring in subject matter experts. The mediation, you might need a subject matter expert. The mediator can't be expected to go and become an expert in that field. Co-opt subject matter expert as a co-mediator. I think you should pay rigorous attention to regulation. If you would like us to start, I will send you my standard practice procedure. But I spell out very clearly what I want parties to do. Give me both the parties to give me a note, head of the mediation, not running it more than 6 days. I exchange the notes. I have prior meetings with counsel and with parties ahead of the person. Get them to think on certain lines. So at the first session, I like to hit the ground running. Actually get to brass tacks. Tell me what it's about. One, this settlement. What are the options you have? What are your suggestions? Settlement. Hit the ground running. Once you hit the ground running, keep the heat on. Get to brass tacks. I know I'm talking like a tank commander, but it works. I think you should bring in government. While the Act does permit commercial government, it also has the provisions for the other government. And this is a center sponsored by the High Court. Government, I think, will find it easier to send up. There is a provision made in the Act. I would also suggest that you consider the use of AI. I had a very interesting discussion yesterday with one of the juniors named Mohit Mokar, who's got his own organization. But he said, I've developed a program, take the facts of the case, put it into the AI algorithm, and I can come out with something to the path. When into litigation, come to this thing. How long will it take? What will it cost you? It will come out. Similarly, for other things, the mediation. And I said, what is the cost of getting a very low fee? It is well worth trying them. Nothing like a party speaking, oh my God, if I don't settle here, this is what I want. I want you to succeed. I don't want you to succeed.
ultimately mediation should become a full profession. And a full profession is when there are professional fields acting independently, large professional fields, so people come to them on their own. We must build up. We must build up. So we should have brand synergy, full professionals operate independently. And we should have the alternate mediation system, which really then should act like legal aid act. And parties should, all mediators should volunteer time for that. And this wonderful in between idea that you now have. Centers are engaging in practice. That would be a very wonderful scenario. In the long run, the point of this profession. And I would tell you, mediators here, enjoy your success. Enjoy your mediation. Fantastic way of bringing about betterment in housing. So enjoy what you're doing. Amidst all the frustration, enjoy your work. Do not get destroyed by failure. Do not get destroyed by failure. Because it's not in your hands. Every case has its own dilemma. And it's really not in your hands, 100%. Don't get destroyed by failure. But only ask yourself one question: whether you succeeded or did not succeed. And I never use the word failure, not succeed. Whether your mediation succeeded or did not succeed. Ask yourself one question: did I do my best? That is, if you answer that well, then my friends, you make it. God bless you. God be with you.
Thank you, Mr. Anju, for that. In fact, while he was talking, I was thinking during the drafting of the bill, we used to have a lot of debates and sometimes you will quarrel. And when the heat goes up, when it's an online meeting, I switch off my camera so that he doesn't see my frustration. So, likewise, of course, he was giving you some advice and how to do it and how to take it forward. Let me take one objection to what he said about AI. Because we have tried AI in many matters, but we thoroughly failed when we consider how the courts will behave. So if the AI says that this matter will go to the court and you will win, you may not. And the courts, if the AI says that you will not win this matter, you may. So I will never ever go to AI and ask what will be my fate of my case if I go to a court. It's like being your dice. That's it. You just try your luck on one day, you may win. Next day it may not be the same. No offense to judges, but I will not. I strongly object to that point. Don't look at AI to see what is your fate of the case and try mediation. Try mediation because mediation, as he said correctly, is a different method of dispute resolution. It is like arbitration, it is like litigation. There should be no reason, as he said, why the mediator should not be paid and only the arbitrators and judges should be paid, because all of them are drawing resolutions. When we are talking about commercial resolutions, it is not a pro bono activity, because the litigants are also looking at commercial benefits. And the mediator can give the benefit, why not pay them? So I fully endorse that view. I now look forward to Mr. Hasan for his views. Come on with
Bias Fabian hard act to follow to speak anything about mediation. This is the first word and the last word in this. So considering that, I have some points to make about the process of mediation and what mediators do and what could be done in terms of thinking about the process in a new case. Lots of people from the commercial side, this as like a touchy-feely process. The sense that how can things be resolved by just talking? Because in business, negotiating is done all the time. Whether before the contract, in the performance of the contract, even after the contract goes wrong, and sometimes people parties limit negotiation is a field by itself. I mean, so it's not unknown to them to talk. So they do ask, like, what will the mediator do? What will it bring in terms of positive things to the process? And there's a question that, what really is the value that is brought by the mediator? And then, so one aspect which is there in Sir's books, I mean, the commercial monograph one, which I highly recommend for everybody interested in commercial disputes to read. It's a slim volume. His other book is very fat. Is the process of creating options. In 2008, I took courses at the Harvard University on the campus. One was on negotiations. It's called PIL-PON, a program of instruction for lawyers, taught by some very legendary people who invented the field of negotiations, in a sense, systematic study of negotiations. And another with Professor Sanders on mediation. One of the aspects common to negotiations, mediations is creation of options, which you also mentioned. That creating options is very central to the process. If parties themselves create options and negotiate across the table, it will be very easy for them to resolve. But you need a trained mediator to create options, present options, and let the parties evaluate. Let their advisors also evaluate whether if entering into a mediated solution based on such options is a wise thing. So I have 6 or 7 points, which I want to make about this process of creating options. 8 points. So the first point I want to make is from the commercial parties' viewpoint. What do commercial parties' viewpoint about the disputes and settlement of the disputes? And why, the insistence, despite, all the negatives that exist about the litigation process, it's an amazing thing when you talk to foreigners or scholars abroad that our courts have such delays and, like such backlogs. They say, why are still people coming to courts? And if you look at national judicial data grade, the numbers are just increasing. There is no letdown to, like numbers increasing. That because of delays or because of, like backlogs, etc., people are not stopped coming to courts. Do they have alternative solutions or not? That's one aspect of it, whether it's in mediation or like in other area methods. But there is, for commercial parties as a subset of these litigants, I can say in common terms, and I'm going to get into technical stuff in short points, a little later, but it is FUT, fear, uncertainty, and danger. If we take this path, what are the fears that arise in the minds of commercial parties? What uncertainties does it generate? And what are the dangers, known and unknown, which will come up if we enter into this mediated sector? And that's behind this thing. More than cost-benefit analysis, more than discounted flow analysis, or any sophisticated financial analysis, in the business minds, these 3 things are at the top of their mind. And how will the mediator address those points? As Panchu said that emotions matter a lot, and we think that commercial mediations or negotiations are only about numbers. That what's the profit? What do I get out of it? And how do I get it early enough? That's clearly not the point. There is lots of emotional burden. The disputes between contractors and subcontractors, dispute between the original equipment manufacturers and their suppliers. The Tata Motors makes a truck, but there are, like 1,000+ suppliers to supply goods to them. And what is a common problem? They give a design to a vendor, you set up a manufacturing plant and suppliers. As soon as, like the vendor sets up a plant, supplies to them and applies to all manufacturing across, immediately what the OEM manufacturer does, they develop other competing vendors. So this vendor is struggling for work. And like they are negotiating and then they are juggling, like we give you a little bit of order here, a little bit of order there, and they are at tenterhooks. And all the supply chain agreements, they lead to disputes only on this aspect that the smaller supplier in the chain feels an immense power imbalance because there are only few buyers who would buy the kind of goods they are making. They are completely at mercy of those goods. So, I mean, that's just an example, but fear, uncertainty, and danger is rife across the commercial disputes. And how do we address it is important. You can sing praises of the process. That is a great process and it leads great results. But whatever be, like the mechanisms, whatever be the training, ultimately in the practice of mediation, fear, uncertainty, and dangers of commercial parties have to be addressed. It may be a smaller party on one side, larger party on one side. Power imbalance is there. It needs to be addressed. Then those things have to be considered. So FUD. The second is, a very interesting aspect. A lot of disputes have insult as the core seed of the dispute. Even in commercial dispute, we think, like insulting behavior or insulting treatment is common in say family dispute matters. So there was, like one case I forget it's called that the wife called, like the husband, like you're like a choda hathi, you're a small elephant. And that dispute went up to courts and they said that, no, it's not, like mental cruelty to say so, and something like that. So insults are very common in personal disputes. But in commercial disputes, also, insults are the lots of disputes. And that needs to be addressed by a mediator. This needs to be seen. How do we, and when we say mediation is a process, a healing process. Because the settlement will be only be sustainable if the underlying issues are resolved and the expression of that resolution is the settlement agreement. Then that insult needs to be resolved at some. How it's to be done, that is the art of the mediation, but that needs to be resolved. Third thing, risk is the moving target. The business world understands risk like nobody else. I mean, lawyers, we are advisors to businesses or we are advisors to parties, but risk is a moving target they deal with everybody. Somebody, is putting up a construction project, not less than 50 permissions are required. They already know what risk they are getting into. Even a person who books a flat in a scheme, they are also participants in those 50 risks that, like a construction contractor opens himself to, environmental, CRZ violations, lots of land permissions, anything and all kinds of disputes can come up. The risk is the moving target, and a mediator needs to keep this in mind that what may be the position when they start, what will be the position of the risk when the settlement agreements happen, and to keep it sustainable, what may happen into the future. So risk as as what we know in lawyers that burden of proof, Section 100 Evidence Act, it's a moving target. I mean, it keeps shifting. So in the same way, risk also needs to be addressed. Fourth one is an aspect that, in all this process of the building of solutions and options that are presented to the parties, you need to think beyond, like the tools that we have. And I have some suggestions for tools that have come across, and they have developed solid academic literature and research, and number of like universities around the world are doing excellent research. And this is based on solid rational tradition of scientific research. These are the aspects I want to keep first. One is behavioral psychology. We know of psychology as something curative and like coming from Freud and all that, all the psychoneurosis and the mental problems. But there are a number of aspects of behavioral psychology which are studied, which take us to this a great conclusion that human beings are not as rational as we think. And a mediator must
and the mediator help in creating options for the parties. What is that go? The mediator may not also be a subject expert on it. So that is where or any mediation agreements. Because see, when we say that the lawyer is a alternative for mediation, the lawyer is also the solution to mediation. If we are practicing, we have been taught adversary mediation, how to find the fight for your client, how to establish your right-based evidence. But mediation is a totally different body where you need to address the interest of the other side. You need to get the acceptance of the other side to get a solution for yourself. So you need to develop options. In fact, in the morning, the association president said that they should just start training them as mediators. This is a new thing. As get them training for mediation advocacy. Excuse me, one mediator, you need two mediators. So what the association will be looking at is train the mediation association members and lawyers in mediation network. In fact, if you're going to an architect now, you consider it. We'll be looking at options where you can build with glass, you can build with other materials, different options which the professional has. Suppose you're going to be a doctor. Giving the signature has to be the just with that. Because it has to be there, execution has proved that it was a mediation. If it is endorsed as mediator, that's accepted. Otherwise, doesn't be proved that it was conducted as a mediation process. That it was an execution. Make a mediation agreement and it should follow with that.
The aspect is that whatever happens in mediation, this cannot be brought to the court. You can even apply certain things against you, but that cannot be brought as evidence in court.
What happens in the mediation room confines to the mediation. It cannot be brought as a even in the mediation or mediator as a witness. It's like what clarification question. Like a civil task is mediation agreement also you should have some of features of like those elements. Court and explication or in other words. It does ask a different this is all that feature as yeah, if the being done, but see, you get even Hon'ble awards. Hon'ble awards need to be the decision finding. And in both in the case of Hon'ble award and in the case of mediation, actually it's not a free body. These are literally executable aspects. It's not cases. So you don't have to have the entire features predicting, but it should be clear and executable. Because it should not be like a moral obligation or like a suggestion. But even if the parties are not getting a conversation, it should be clear. Because the court should see that suppose it's a money asset, and the happy that this money will be paid, this amount will be paid, what are the people paid. It's a clear decision by the court. So that can be executed. But the proposal say the money will be paid. That cannot be executed. So it should be clear.
For important mediation. Mediation after the drafting of the agreement. If it is also, if it will be put to the court and court will have it put in all the terms. What can suggest? What can return it for return it to the mediation? So have it complete draft. That doesn't. Whereas in other cases, unlike in important mediation, the mediation comes prior to the issues coming before the court. Then an agreement is drafted and could be for the there won't be any court scrutiny. Then what would be the impact if it turns to be if the terms turns to be not executable?
It will not be executed because it's again because see there is one loophole in the act right now because the unlike the arbitration ultimately is set aside by the court. Then the entire period from commencement to set aside is excluded from the period of mediation. But unfortunately, the Mediation Act right now, even though we had suggested that, no, it's not there. Right now, the only two grounds are suppose the party going for mediation, the time when the mediation starts, and when the mediator gives a report saying that it is not possible for a settlement. That period is excluded. That means the mediation time, the time which they took for mediation is excluded. But suppose the parties enter come to a settlement, and later on,
there is a provision in the Legal Services Act. You have to go for a pre-litigation mediation settlement, and that period taken for that will be excluded. It's like that.
and that is there. That is there.
In the Legal Services Act,
But in the Mediation Act, in the new Mediation Act, one problem is suppose the parties come to a settlement. Thereafter, it is taken for execution. Later on, the court set aside on some ground. Then that portion is not excluded. So then, suppose the court takes more time and the period of litigation is over once the setting aside happens, then the party will be remunerated.
No, it did not come under section 14 of the Mediation Act, where I have qualified.
Yeah, but it's not a it is excluding the time. If suppose you are that is only that only happens if you are in the wrong part.
This we can debate later on. I will say no, I will put it the other way. Suppose you are getting a statutory recognition for mediation, and if you say that the mediation agreement is going to be that of a decree, can it not be taken as a quasi-judicial process for by which this also will not be taken care of? Otherwise, what is the purpose?
I think we can take a call on judicial side. Yes.
Because that will not be taken care of. Otherwise, I don't think that people
We have to
will
take a call on-
expect that.
Yes.
Judicial interpretation may come that way, whether outgoing section 14 can be elastically extended to those things.
No, but the problem is like the Arbitration Act, which is a self-contained code. Litigation and all the aspects are contained in the code itself. So likewise in mediation also it's a self-contained code. The limitation and the exclusive limitation is given in the act itself. So maybe we cannot borrow it from outside. Very well.
Right? Because
Any questions? We'll take two more questions. You want to mediate?
Sir, I'm a member of Builders Association. Presently, I'm doing government contracts. So in government contracts, especially state government contracts, there is no arbitration, there is no mediation. So during the execution of work, if there is any dispute occurs, what we will do? Only is civil code is
I love to try to legal advice. So you have a contract, the contract doesn't have arbitration. And it's a problem. You should know exactly what we are talking about today. You should approach the center, set up on the high court. Say, look, this is my contract, this is my problem. The center will contact the government. Say this party has come, he wants mediation. But because this is a high court center, government won't say I want mediation. They won't say. You will have to come. You will have a chance to sit down with the government and mediate, and the mediator appointed by the court. And the government also now realizes that they should not be too unreasonable. They are also, I mean, internally they are talking. They are also setting up systems by which the government officer will be allowed to conduct the negotiation. And then there will be a high level. You will take the settlement proposal. High level committee has to say yes. And once the high level committee says yes, nobody will have any fear of any consequence or investigation. So government is also working to set up a system. The big thing in this initiative today is that it's set up by the High Court. And if the High Court is in our center, government has to come along. That's why I'm so happy. It's a very big issue.
just supplemental question. In fact, government used to have a clause in arbitration back in the 1980s. But some issues in corruption issue, Colorado project, government brought a legislation, refusing all, even pending arbitration. That legislation, of course, last year Supreme Court was struck down. The government basically is not interested in arbitration for business. They suspect some kind of corruption. But certainly government can be part of this because this is, unless government evergreen high level committee as suggested. Certainly we also are going to have kind of part of the government commissioners and other ministers and responsible. Hope that they will also support this government.
But in the book, I suggested that the whole chapter on government mediation. Yes. The chapter on government mediation, the book, yes.
That's right.
They are going to take it seriously. In fact, I had a meeting with the Advocacy also. And he's also very caught up with this idea.
Whoever is going to raise the hand first? Yes.
So my name is Kilden. I'm the leader of my question is comparing to mediation. The role of a mediator is very low when comparing to arbitration. Then also in the process of mediation, the both parties will be come to a conclusion, and only we can make it as an award, then entries. But my question is, when comparing to mediation and arbitration, if we want a speedy solution, then the arbitration is the best way of the solution. When comparing to mediation, also the level of success rate is very low. Then what the suggestion regarding to this?
Whom you would want to answer from?
Anyone?
So, the current thinking in dispute resolution is to come up with an appropriate dispute resolution method. So not, like choose arbitration over mediation or mediation over arbitration or, negotiations as such, but what would be appropriate for the dispute. In some disputes, arbitration is a more appropriate method because both the parties would want a quasi-judicial analysis of the evidence and come up with a number. That may be because a lot of calculations are involved where, let's say, if you are in construction field, I can tell you there is an issue called concurrent delays. Both sides have delays. So now how to apportion liability? This can be resolved with mediation if both the parties, with the help of the mediator, can come to a number. Our courts have held in decisions, in most of the concurrent delay decisions, 50% fault on both sides, which is not really an analysis. So it maybe arbitration is a better method where concurrent delay issues, deep issues are involved, and both the parties would want it resolved only through the arbitration process because nobody is sure on whose side the delay is more because there has been delays on both the sides. So maybe so what I'm trying to say is that appropriate dispute resolution method is a better filter as compared to saying that one is better than another or another is better than another. Yes, if a mediated solution, even in such a concurrent delay solution situation occurs, then yes, if parties can agree and mediator can propose a solution based on many factors like how much time it will take to arbitrate, solutions, challenges, all things taken to consider. Parties may want that, all right, we may not get a finite number as such, a very calculated number, but we'll get a solution which works for both of us commercially. So then they may accept the mediation. So the idea is to choose an appropriate dispute resolution.
So just adding on to that, one of the we have always been talking about the pros of when you're talking about the pros and cons. We're always talking about the benefits of mediation. But one disadvantage of mediation is there is no guarantee of an outcome. Because when you enter mediation, generally up to the parties to come to a resolution. So there cannot be a guarantee of an outcome. But in arbitration, definitely there's a guarantee of outcome. And the problem is when you're talking about fast resolution, arbitration may not always be a fast resolution because post-arbitral proceedings can take time in court. There can be a stay and there can be enforcement difficulties. So the best option in those type of contracts would be to have a hybrid clause where you can have a MEDAP or an half-MEDAP clause where you can attempt mediation first and there's a trigger of mediation directly go for arbitration. So there's a guaranteed outcome in the dispute resolution clause itself. And the first option would be to try to resolve it amicably so that the party can get the best outcome from the dispute. Or if the parties are unable, don't wait for any other option. Press the second button so that you go to the next step of arbitration. So you can uninterruptedly proceed with the dispute resolution process and get a guaranteed outcome. So I think the time is over now. I will request the chairman of the meeting to conclude this month.
So, I believe in mediation. And in fact, these people are to believe in mediation. From your questions, I do understand that you are not quite familiar with what is mediation. You must learn more about mediation, and you will certainly understand that mediation is the best way of dispute resolution. It is sublime way of dispute resolution, especially in this commercial dispute and especially in construction disputes. But I've been doing arbitration in construction for long. Almost 9 years I've been doing arbitration.
You are also familiar with arbitration and.
Yes. And most of the construction disputes, the main question is regarding delay. It is the for finding solution for that. Mediation is the best. But because people do not know what a mediation is, people are not coming forward for that solution. So you people can do a better way of educating your participants in adopting mediation for resolving disputes. So, shall we conclude the discussion?
Thank you all for this insightful discussion. We'll be having a short lunch break now and we'll commence the third session afterwards. Lunch is arranged in the adjacent room, committee room. We have some space constraints there. So please feel free to have your lunch in this room also. And we have arranged hand washing facilities outside the banquet hall. So we request you all to kindly join us for lunch. And the third session, we expect to resume it by 2 o'clock.
ഇത് കണക്ട് ചെയ്താൽ
ചെയ്യാൻ പറ്റുമോ?
ഐഫോണിന്റെ ചാർജർ ഉണ്ടോ?
പിന്നെ ഒരു നഷ്ടം വരും. അതുകൊണ്ട് ഞാൻ പറഞ്ഞത് രാവിലെ
അവിടെ തുടക്കത്തിൽ പിന്നിട്ട് നോക്കിയാൽ മതി ലൈക്ക് പിന്നിട്ട് അത് പ്രൊഫസർ നടത്തിയിട്ടുണ്ട്.
രണ്ടും തമ്മിൽ കമ്മ്യൂണിക്കേഷൻ ആദ്യം വന്നായിരുന്നു. ആദ്യം ചേട്ടൻ വന്ന് സെറ്റ് ചെയ്ത് എനിക്ക് തന്നപ്പോ സെറ്റായപ്പോ കമ്മ്യൂണിക്കേഷൻ വന്നു. പക്ഷെ അതിനകത്ത് യൂട്യൂബിലേക്ക് ആ URL കൊടുത്തിട്ട് കൊടുക്കുമ്പോ ഇപ്പൊ പോകുന്നില്ല. ഇതിനൊന്നും കാരണം പിന്നെ ഒന്നും വന്നില്ല. ചേട്ടൻ വന്നിട്ട്
എല്ലാം കൊണ്ട് സെറ്റപ്പ് ചെയ്യുന്ന പറഞ്ഞു കേട്ടിട്ടുണ്ട്. അതുകൊണ്ട് പഠിച്ചിട്ടാണ് ഞാൻ പ്രോഗ്രാം
കുറച്ച് കഴിയുമ്പോ ഇതെല്ലാം കൂടെ ലിങ്ക് ചെയ്ത് ഓണാവുമ്പോ
Types are very. അതൊക്കെ USB കണക്ട് ചെയ്യാൻ പറ്റും. സോണി ബോർഡ് സ്ട്രീം ചെയ്താലോ ഷെയർ ചെയ്താലോ ഇതിനകത്ത് കണക്ട് ചെയ്താൽ സൂമിൽ ഷെയർ ചെയ്താൽ മതി. അല്ല ക്യാമറ അല്ല ഇതിൽ കണക്ട് ചെയ്തിട്ട് പ്ലേ ചെയ്താലും മതി. ഇതിനകത്ത് സ്വിച്ച് ചെയ്ത് കൊടുക്കാം. എന്നിട്ട് പിപ്പിനകത്ത് ഞാൻ വേണമെങ്കിൽ പ്രസന്റ് ചെയ്യുന്ന ആളെ കാണിക്കാം. ലോങ് HDMI ഉണ്ടോ? തേർഡ് സെഷന്റെ ഒരു റിസോഴ്സ് പേഴ്സണിനെ സ്ലൈഡ് പ്രസ് ചെയ്യാനായിരുന്നു. ഇപ്പോഴും അവര് പറയാം സ്ലൈഡ് USB ലാണ് ഉണ്ട്, ലാപ്ടോപ്പിലാണ് കിടക്കും. സ്കാൻവേലാണ് ഇട്ടേക്കുന്നത്. അപ്പം ഈ ലാപ്ടോപ്പ് കണക്ട് ചെയ്യാൻ പറ്റുകയാണെങ്കിൽ കുറെ കൂടെ തോന്നുന്നു. അറിയില്ല ലാപ്ടോപ്പ് അവിടെ വയ്ക്കും. ഇങ്ങനെ അവിടെ വെക്കാനായിട്ട് സാധനമില്ല അല്ലേ? ഇരുന്ന് പ്രസന്റ് ചെയ്യാൻ പറ്റുമായിരിക്കും. ഇന്ന് കണക്ട് ചെയ്യണമെങ്കിൽ ഇത് കണക്ട് ചെയ്ത് വെക്കാൻ പറ്റും. ടേബിളിൽ നിങ്ങളുള്ള ഒരു കേബിൾ ചെയ്യണം. ആ സമയം അതാണ്. എവിടെ നിന്ന് ലാപ്ടോപ്പ് വെച്ചോട്ടെ. തേർഡ് സെഷനിലെ വരാൻ വന്ന അടുത്ത സെഷനിലെ അവസാനത്തെ സ്പീക്കറായി. അത് കണക്ട് ചെയ്ത് ഇതിന്റെ കണ്ടന്റ് ഒന്നും പ്രസന്റ് ചെയ്യില്ലല്ലോ. കണ്ടന്റ് ഉണ്ടോ? ഒരു ക്യാമറ മേടിക്കാം. ആ ക്യാമറ ഉണ്ടാവും. ആ ക്യാമറ ഏത് HDMI ആണ്? ക്യാമറ ഇല്ല. വലിയ ക്യാമറ അതിന് ഒരു ലാപ്പ് ബോഡിയിലാണ്. അത് HDMI കണക്ട് ചെയ്തിട്ട് ലാപ്പ് ഈ ക്യാമറ യൂസ് ചെയ്യാം. ആ ക്യാമറ
ആരെങ്കിലും ചാർജ് ചെയ്യാൻ കഴിയും. ഇതൊന്ന് കണക്ട് ചെയ്യാനായിട്ട് അവിടെ ചോദിച്ചു അതിൽ കണക്ട് ചെയ്ത് കൊടുക്കും അതുകൊണ്ടാണ് ലൈവിന്റെ ഐക്കൺ ചോദിച്ചാ അതെങ്ങനെയാണെന്ന് അറിയാൻ പക്ഷെ ഇത് പോകും സ്ക്രീൻ ഷെയർ ചെയ്തേക്കും ഈ സ്ക്രീൻ ഷെയർ ചെയ്തിരിക്കുക അല്ലേ
Yes.
Can you just, yeah. Do you have to remote the projector to change the slide? No? Okay, that's fine.
You have a laptop.
We do have laptop as well.
We have connected cable on diet on podium.
Okay.
Then you can connect HDMI.
That's
Full slides.
But if I have laptop, then should I take that option? Yeah, because it will be easier for the presenter to change the slide than somebody else change the slide. Yeah. All right. So I'll take the time.
Yeah. The presentation is like an online link. Online. Yeah. So can I share it with you and you password? Yeah, like you can just no. You just like open it in your system, and then we can use it during the website or yeah, it's a pitch. It's a pitch app.pitch link. I can just mail you, WhatsApp you, whatever you can, whatever is easier for you. The soft copy. No. Like if you want, I can also connect my laptop. That won't be an issue. That's it. Laptop connecting is a problem. No. You can connect HDMI. You can connect to HDMI. HDMI. Okay. HDMI is and on podium. Okay. Then just you can connect HDMI. Then you can see on this screen. I can change it from there. Yes. Just like, maybe you can. Yes. Yeah. Sure. Sure. Okay. Yes. എന്നുള്ളത് ഇത് നമ്മള് അതുകൊണ്ടല്ലോ വേണമെങ്കിൽ അത് മാറ്റി കൊടുക്കാറുണ്ട്. അപ്പൊ മാറ്റി കൊടുക്കാനുണ്ട്. അതെന്താ ഞാനൊരു ഇമേജ് ഇട്ടിരുന്നല്ലോടാ.
We commencing the third session soon. The third session will be a panel discussion on the topic
Camera
role of
on.
power in mediation beyond compromise. I request everyone to kindly occupy the seat so that we can comment to the session without further ado.
Camera on. Presentation, another test. ചേട്ടൻ കഴിച്ചു ഇല്ല ചോദിച്ചോളാം ഞാൻ മറ്റേ രണ്ടുപേര് കഴിക്കുന്നുണ്ട് മറ്റേ പിള്ളേര് കഴിക്കുന്നുണ്ട് തോന്നാറില്ല
We will start with the third section of the topic, role of lawyers in mediation beyond courtroom suit. I request everyone to kindly occupy the seat so that we can begin the session without much delay.
ഇപ്പം കണക്ട്
The third section of the panel discussion on the topic, role of lawyers in mediation beyond courtrooms, which will be presided over by Hon'ble Mr.Justice Joseph, member, Board of Governors, Kerala State Mediation and Conciliation Center. Advocate mediator and trainer with Mediation and Conciliation Project Committee to be the moderator of this session. We have a distinguished panel of speakers comprising Advocate Ramkumar Nandiarvi, Advocate P. Srikumar, and Advocate Johnson Gomez. May I invite Honorable Mrs. Justice Joseph, the President of the session, to address the orders gathered.
From the sleeping mode to the active mode and listen to the session slightly. So my role is to address you on the role of lawyer in mediation beyond court. So majority of you might have been addressed so many times with the role of mediators in mediation process. So now my task is to address you on the role of lawyers in mediation beyond court. So the role of lawyers, both in the court and mediation as well as in the other kind of mediation beyond court, are one and the same. Lawyers have to promote the parties, or else to address the parties. Primarily, lawyers have to address the parties that such sort of mechanism is there to settle the disputes effectively, so that both parties can win and both parties can leave the mediation table satisfactorily with their own terms put to execution. So that is the lawyers have to address, communicate to the parties that this is an effective mode of settling the dispute and make them aware that by resorting to such a mode, they can get their disputes resolved within a short term of time and also without much expenses being involved. So that is the major role. Now coming to in the morning session, enough introduction, enough address. You have been addressed with all sorts of various aspects of mediation process in the morning session by luminaries in the field. So one thing I got from the discussion was that, so I will tell firstly to the mediators. The mediators have to see that they must be aware of the law in which the settlement has to effectively enter into regarding the issues involved. So they must be familiar with the law. Otherwise, in the morning session, I have put a question. That question is very relevant in the field. Why? Because if in a mediation out of court, prior to reaching the court, in that mediation process, if the mediator who is not aware of the legal aspects, if coming into terms of settlement and arriving at terms of settlement and execute a deed, and when that execute an agreement, and when that agreement is put for execution, if the execution court finds that the terms are not enforceable, then the answer given was that there is no solution, no remedy there. The award would be returned to the party so that they can again approach the mediation process. Then the question comes, if the matter is covered by limitation, then what the parties will have to do? The result would be that the parties would lose faith in the system itself. That would defeat the entire purpose of mediation. So, to my mind, two things have come. One is that the mediator must be thoroughly studying the legal aspects of the issues. They must be thoroughly aware of. And they must see that the terms are entered into effectively and in an executable manner. The second thing is that I don't know that provision is there or not. Anyway, I am suggesting that the second thing is that when the terms of agreement have been drafted and coming to the court for execution purpose, then an independent machinery must be set apart for verifying or scrutinizing the terms of settlement. And they must see that the terms are effectively drafted and those could be effectively executed. And after that, if that is sent for execution, then that can be resolved. These are the two aspects. These are only suggestions. I do not know whether the provision is made in the act for that or not. I do not know. This is my suggestion. Otherwise, the entire process would be fruitless, and the entire the party would lose faith in the system. Then another aspect in the morning, it has been said that mediators and lawyers must see that while addressing the parties, they must see that the parties must be communicated effectively of the benefits of the system and how the system would function. That has to be effectively communicated. In the morning session, somebody was asking a doubt about what is the difference between arbitration and mediation. See, much criticism have been leveled against the judiciary for pending backlog. And then Parliament has thought of introducing Section 89 into the CPC, and alternative dispute resolution mechanisms have been introduced. Those are, for your awareness, I would say that those who do not know, I would say that those are arbitration, conciliation, logakala, legal settlement, and mediation. Among the five, most important is mediation. Why? Because in mediation, the parties themselves have to arrive at the terms of settlement. Mediator must be there beside you to prompt you or to guide you to arrive at the terms of settlement. Whereas in an arbitration, the adversarial mode of dispute resolution would be followed. In court, what would be done? Court, if two parties represented by lawyers, they will put forth the case to the court, and ultimate evidence will be taken, argument will be effected, and after that, a decision would come. And that decision would be from the mindset of the judge. Judge would read the evidence, judge would analyze, appreciate the evidence, judge would hear the counsel, and thereafter the judge would pass a judgment, and that would go for execution. Whereas in mediation, the parties themselves would arrive. The mediator would have to address them that they have to arrive at terms. In the morning session, one suggestion was put by one eminent speaker that the mediator has to take down the terms of issues into writing from the parties itself. That's a good suggestion, because parties themselves have to put into writing what are the issues that have to be resolved among them. Each party, when that is put into writing and placed before the mediator can effectively enter into terms of suggest them to arrive at settlement in such a mode. He can help, mediator can help. Firstly, what has to be done by the mediator is to understand the issues of the parties effectively. Then alone, he can settle the issues. If the disputed aspects were brought into writing from the parties, then that can be analyzed, and mediator can sit by the side of the parties and to prompt them to arrive at the settlement in such manner. Mediator cannot impose any terms to the parties. Mediator can only guide them. This is a proper resort to arrive at the amicable settlement. And if you can opt for that, you can. Otherwise, you suggest your own terms. And if terms are good, then that would be that can be endorsed into an agreement. So this is the way in which that's the difference between arbitration and mediation. In mediation, parties themselves arrive at the terms of settlement with the aid of the mediator. Whereas in arbitration, like in the court, the judgment would be arrived at. So in the morning session, another luminary has been suggesting that in commercial contracts, fear, uncertainty, and damages. These are the three aspects worrying in the construction field and in commercial matters. So these aspects must be taken into heart by the mediator himself. When the parties approach him in the mediation table, these aspects must be taken care of by the mediator himself, and think that these sort of aspects are that of himself, and he must arrive at the terms of settlement in a manner how he would reach a settlement in if his own case is resolved. If his own case is meant to be resolved by him, in that manner he has to act. So this is the difference between these two, and now the aspects would be addressed by various persons, and if any doubt is there, that would be clarified later. So I wish all of you a good opportunity to attend the process. And my first suggestion, I am again repeating, change from the sleeping mode after having a delicious food to the effective mode of listening. Thank you very much.
May I invite Advocate Sriram Varia, mediator and trainer MCPC, to moderate the session.
A very good afternoon and warm welcome to the third of the sessions. Honorable judges of this honorable court, senior counsel, respected guests, mediator trainers, mediators, and all others who are here. I'm sure it's a rare opportunity that most of us get to have experts talk on certain topics which are not regularly being handled by us. Though they are very, very important in life as well as in your professional side. And the topic that is now chosen for this session is a role of lawyers. I read it once again. A role of lawyers in mediation beyond court. And I would underline the word lawyers. You're wondering why this word has been used and why not advocates. That makes the whole difference. A lawyer has excellent knowledge or is a specialist in law. And he knows the expectation in law when it comes to matters of dispute resolution. An advocate is also trained to fight for something. The whole dimension is different. Lawyer knows what is expected of law and what one may achieve. He has a neutral approach to any issue and he doesn't go for a side. He looks at it very neutrally. And I believe hence the word by the organizers, lawyers instead of specifically placing the words or probably replacing the word advocates. The next is mediation, that was well explained. The second part of the topic is the role in mediation beyond court. Understandably, it is not the routine court-annexed mediation that most advocates, all of us have experienced. So when we go outside in private mediation, is there really a change in the role of the lawyers? Or is it exactly what we do here? It has to be noted that yes, certainly lawyers would have a different role when it comes to private mediation. Given the apprehensions that we had in the morning which were expressed as to the effect or the ultimate product that you're going to get. In private mediation, compared to that of the court annexed, court monitored, court vetted product, certainly the lawyers would have a little extra responsibility. In fact, you are the people who are to guard the parties who are into mediation. Now the role is basically divided into three different ones. One is, we'll assume the mediation starts at a particular point, ends at a particular point where the parties come into consensus. Prior to the mediation starting, the litigants or the disputants normally have some kind of a lawyer or a legal advice. And it's at that stage which I would say the lawyers have a very important role to explain why mediation is important in respect of their dispute. Very convincingly, to tell them the benefits of mediation. We have been saying that yes, certainly that's the best. But for a party, it may not be so, he may not even be aware of. Therefore, the first part is for a lawyer to convincingly explain why we should be approaching one. So certainly the lawyer should be also be thorough with the process. The second part is during the mediation. We all say that it is a party-centered one. Party may have its limitations. They might need a right-hand man. At least when he has difficulties faced, he would certainly look at the best of his partner in pursuing this process. That would be his lawyer, the most trusted one. And the lawyer should certainly be knowing what he should be actually participating and contributing as far as the party is concerned. Therefore, these are divided into three. And the next is post-mediation. So when I say post-mediation, please don't misunderstand by saying that settlement writing is part of, or is it not part of mediation. Mediation is a process whereby parties, they have certain kind of differences or disputes. They ultimately come to a consensus or a resolution. Now there is a legal requirement, which is documenting your consensus or what you have really agreed. Mentally you would have given a shake hand. Said, yes, we have understood. Let's take, or let's go with whatever we have agreed. The documentation becomes very important. And it is the documented terms of agreement which a third person can actually help you implement. So if we assume that mediation is at that particular stage, we have really reached a consensus, then a formal role of documentation is probably post-mediation technically. Now, it is in this context, I'm sure we would all be speaking. We have three other panelists here. You all must be knowing, certainly, especially people from this bar, and also those who are in the construction industry know Mr. Kumar Nambiar. He has been actively involved in the gradized activities. He has also got the credit of having managed several disputes or conflicts, concluded those issues, especially relating to construction of apartment complexes, etc. And he is the first among the speakers. He would certainly share his experiences as a mediator, one, and what probably he would have expected from a lawyer and what he has actually received. The second, we have Mr. Srikumar. Though very silent, he is an excellent taskmaster. Whenever it is given to him, he manages it. And he too has the credit of having achieved excellent success in these kind of construction disputes or in the particular industry. My friend Srikumar would also be literally sharing with you all his experience that he had in achieving that kind of a result. Third, yes, Mr. Johnson Gomez. Probably more than he is known here, he is understood outside our circle. One of those wonderful arbitrators. He is empaneled by many organizations, and he has been specializing in resolution of disputes in the construction industry. He has attended several conferences. He has been a speaker in such of these kind of seminars and conferences. So we are lucky to have him also. So he would certainly share his experience in relevance to the construction industry. The core topic being the role of lawyers in mediation when it comes to outside the court or beyond the court or private mediation. Now, I request Mr. Ram Kumar to address you.
Honorable judges of this court, dignitaries on the rise and off the rise. As Lordship Justice Mary Joseph just said, please switch into the active mode. Because I am not here to lecture on the role of mediation or the role of mediator, because I do not have such experience. And Srikanth Magar has been unnecessarily praising because I do not have any experience, literally zero. I am not a trained mediator. I am just an ordinary lawyer who, out of circumstances, in fact, created by His Lordship Justice Mushtaq, has stepped into this role of, I don't know what you can call me, a mediator or a facilitator, I do not know what. But I'll share with you some of my experiences there. What happened is that it's like it's an experience which I think everybody should know about. See, there was a project. I don't want to name the place, I don't want to name the builder or anybody. There was a project by a builder. It's postulated the construction of about 160 flats, apartments. The builder went abroad canvassed for funds, and there were many investors, including lawyers, who had funded this project. Funded means that there was money with the builder, and of course, asked for apartments. They're all promised apartments. And many of them had paid the full amount. Some of them had paid half the amount, quarter amount, various denominations. And the place in which the building was to be constructed belonged to a completely different person. So I called them the landowner, the builder, and the investors. Now what happened was the construction started, permission was granted, and it went on now in full swing. Once the basic structure was completed, then the builder just vanished. He said he did not have funds, and therefore he just vanished. The investors were naturally perturbed, and they did not know what to do. So they went all around the place, and finally they reached the police station. They filed a criminal complaint. There was a crime registered, and finally the police arrested the builder. The builder, his wife, and his children. All of them were arrested. They applied for bail, was denied by the lower courts. When it came up to the High Court, it was granted. And here it was suggested, why don't you arrive at a settlement? And what happened was they went to the legal service authority. They sort of entered into an agreement and said the building would be completed within 6 months. Nobody knew how, but it would be completed in 6 months. Apparently, the builder did not have money, so the agreement did not materialize. And then the investors formed a society and came up to this court and filed a writ petition saying that they wanted to enforce this agreement, execute it before the test. The question of maintainability was pointed out. But fortunately, we are very fortunate indeed. It came up before the Lordship Justice Mr. His Lordship said that the question of maintainability aside, that is not the core issue. In fact, to our great fortune, the builders were represented by counsel. The landowners were also represented by counsel. So his Lordship said, instead of going legally about this, why don't we try to resolve this dispute? And his Lordship, I have no compassion for me, I have no for what, appointed me as the administrator of this. I was in fact shocked because I did not know the ABC of mediation or anything of this sort. So I thought, his Lordship felt that I am capable of something. I should rise up to the occasion. So I took up the challenge, and then I started individually meeting the investors, basically, about 100 of them. What they said was, when we talk about mediation, the core issues, the points, I was wondering, the core issue was we need to kill that man. This was what they wanted. They did not want to see the builder. They did not want to have anything to do with it. They just wanted to burn him. That's all. Because they said it's their hard-earned money, and this man has wandered away our wealth, and we don't want to have anything to do with it. We just want to finish him off. So I knew things were going to a very bad start off. Called the builder. So he said he came with his sons and said, I don't have any money. So I said, what happened to all the money? So we calculated by then as to how, we asked him, in fact, how much he had spent. He said he had spent about 30 crores already on the project. So before going into that, what I did was, I thought of getting a proper evaluation of the work actually done. So we had some private engineers, and they went and inspected the entire project and found out that it was not 30 crores, it was about 11 or 12 crores that was invested in the entire project. The rest of it we do not know. I don't want to go into that area also. So builder said, I don't have that money. He said he had committed a series of wrong decisions. I don't want to say what those decisions are. He has finished off all the money. There is no money there. So then asked the landowners, so what was their point of view? They said, see, we have given the land to the builder, and we do not have, we were supplied with some funds, but the major funds have not come. We have not been given apartments. What are we to do? So this was the state of affairs in which the resolution of dispute was ordered, and it was handed over. So I had conducted a series of discussions with investors, builders, landowners, and it took almost a year to point out as to what were the core issues. So finally, everybody we could coax them into, I could coax them, sorry, into understanding the problem is everybody needs a home. They've all invested. And for that, you need to build. And for building that, you need money. Where does the money come from now? Unless and until each one of you pull in some resources, we will not be able to start this construction. So that was slowly related to it. And then finally, everybody said, yes, we are on board. And we started the project. We did not start the project. They said they are agreeable, provided the builder is remote. You do not want it. It does not have to form part of this at all. But nevertheless, he should be there so that we need the plans, we need everything, promise everything from him. But we will have another builder to construct this. Then the landowners were also called, they were also agreeable to this. And then what happened was, I said, no, broadly we have defined ourselves as to what is to be done, how we should proceed. But then we should put this on paper, and therefore we had a tripartite agreement between the owner, the builder, and the investors, investor society. And then we formed, once we formed this agreement, we drafted this and we produced it before the court. It's in safe custody even now for this court. Based on the agreement, we started construction. How did we go about it? We started calculating as to how much each person has invested and what is the share that he's invested, how many how many shares are there, what is the portion that would be required for him to construct the what is the percentage of investment that he should be made. All those things were worked out, calculated, and each person was given the amount that he had to deposit or he had to invest. It's everybody was agreeable, fortunately. And then once that was done, this court had asked me to start a bank account in the State Bank of India here. The High Court opened an account, had a separate PAN number for that, and then money started coming. And then it was in terms of crores. Then we started construction. Once the construction started, that is when I realized it is not at all easy. It was very simple to formulate an agreement between the parties, but construction was a totally different ballgame. I was not even aware of that. And then for everything, for civil works, we needed engineers, we needed architects, we needed plumbers, we needed electricians, sanitary fittings, everything we needed. So what I proposed was we will go by tender. So we published for everything, for every work. What we did was we gave out a notice in the newspaper and called for tenders from different builders, different electricians, different plumbers, everything. And every one after another, even the carpenters were requisitioned. And then we got everybody on board and started construction. And by God's grace, we could complete the entire construction. And now people are residing there. This is the sole credit of Project Westminster. Because I was only a facilitator. I can't say that I had done anything.
Modest.
No, sir, that is the fact.
There were issues related to the floodgate.
Yes.
And they were unsolved.
Some are not resolved even today. As regards the permit, in fact, it is an interesting question. That is, permit was of the year 2006. Construction had started. By the time it was Panchayat earlier, the building rules were not applicable. Then it became a municipality. Building rules were made applicable. This is an expired permit, which was the rule that would apply. Fortunately, at that point of time, filed an application for the court and said, this court ordered that it should have a retrospective effect since the construction was already there and it was almost completed. The old rules will apply. We got one issue after another which we resolved because ultimately what I thought was it is in the interest of the investors because basically the project had to be completed because there were 165 people who needed homes and we had to take care of secure their interest because it is their hard-earned money that was invested in this. And in fact, during the construction, one of our consultants was Mr. Setunath. In fact, we used to get his services for expert consultancy. We used to pay him and then everything was accounted for, by the way, don't worry. Everything was accounted for and we got this whole project done. And the best part is everybody at that point of time, I'm told now that people are fighting against each other there. I mean, right now the Residents Association is formed. I guess people should fight. Otherwise, what are lawyers there for? Because I don't want us to go hungry. They should fight. People should fight. As rightly endorsed. But then we can resolve it also. And if it is by mediation, it's well and good. If it's arbitration, it's another. If it is litigation, it's yet another aspect. But then the point being, mediation, I think when we said about training, comparatively, most of the people here are quite senior by age, not by experience, not by practice. So that I would also like to be trained. Because I don't know ABC of mediation. I would like to be trained as to how you go about it, how to manage the core issues. Because from these spaces in the morning, I've learned how to process this whole thing. What I did was by sheer common sense and logic. That is all that I did. And plus whatever little law I knew. For the past 37 years I've been practicing, therefore I knew a little bit of that and therefore I managed with that. But it can't be the case always. So therefore I would request now with this mediation center also. And as the president of the association earlier said, lawyers need training. Be it senior or the junior, it doesn't matter. I mean, as long as I am ready to agree, understand and study the basics of mediation, I think everybody should be able to, should be asked to go through this rigorous training. So that you learn to understand what is the problem, what is the core issue, how to go about it, how to solve it. I think that should be part of the thing. So this is the mediation in which I was involved, and I think a great facilitator was his honorable court, and his honorable court had absolute trust, and I had to having reposed the trust in me, I should have been equally responsible. Therefore, I did it. Of course, I should not be forgetting that I was paid a handsome amount also for the services rendered. Because from 2015 to 2021, it took about 6 years to complete the project, and now people are residing there. I was paid a handsome amount also. Now, that is one experience. The second one is it's not a construction. It's just about mediation. I was just thinking about it in the lighter way. This was before my marriage. I was about to get married, and then there was a divorce OP before a court, for a sub court. Those days it was not a family court; it was just a regular sub court. So, and we had a lot of cases there before that court. So, what happened was when I went there, the judge said, "You're getting married, aren't you?" I said, "Yes, for the next time." You want me to come for the wedding? Yes, and they honored us. The honor of come and attend the wedding. And then you tell this matter. This was a listed matter of a divorce OP, and the honor was asking me to settle it. Again, by God's grace, we could settle it, and they reunite. And the best wedding present was both of them together for my wedding reception. And they are still together. Their daughter is about 23 now. Right? So that was the best part of mediation. So there are good points also in the side of mediation. There are certain things which happen, by the grace of God. I think this is all that I have to share. A little bit of small experiences. That is all that I can say. I do not know the intricacies of mediation. So forgive me if that said something wrong. Thank you, Jay.
Steve will also be sharing his experience in the same manner.
I was arguing against before this court. I would have simply said I fully endorse what Ms. Lana said because we were in an identical situation. I was also appointed as a chief settlement officer in one project, and I had to undergo almost all similar procedures in this case also. But before going into that personal experience, I must say one thing. That today, all of you who are sitting here are trained in mediation. And one should understand that in the present age, the mediation will be the keyword. It is for different reasons. Why? Because when our country is moving forward, when we say we are going to be the third financial power, etc., whoever comes to our country for investment, whoever wants to use India's credentials, they will be looking forward to have an easy and simple dispute resolution system. So when the country has to develop a judicial system or a dispute resolution system is necessary, and it should be civil also. The most beautiful thing about the mediation, in the mediation process, the parties to the dispute, they have a say in that. Unlike in a court where they go before the judge, we read on the say about the law, regulations, etc. In a mediation, the decision is rather based on facts. The client will have a say. And another thing is that they can come out with wonderful solutions, which you may not get in a court. Because my experience as a settlement officer is one such thing. Because you know, when we file a petition under Article 226, you will often raise or meet objection from the court and our lawyer saying that this is beyond the scope of 226. You cannot invoke this jurisdiction because this is a construction thing. The construction, the builder has paid the investors. How can this court go into these details? These are things which wanted evidence, long process, etc., etc. But when this court feels that even when an investor has invested money in a building project and the builder is also doing a business, all these persons are entitled to have their fundamental rights protected. But how it can be protected, the way in which it is to be done, is what this court should look into. That is why, when one particular project was abandoned by the builder, there were 142 apartments were there. And there was an arbitration proceedings. Arbitration proceedings culminated in certain settlements. But nobody was benefited. Then one petition was filed before this court, saying that that the sale transaction has to be sale deed executed. In the normal sense, any judge of this court acting under 226 should have said, no, you cannot invoke this jurisdiction. This is a different thing. But when a particular court feels that this is a matter which is to be looked into because this is a matter which involves crores and crores of some investment of about 140 people, because you know, whenever a person tries to invest in a building, in a home, he is availing loan, he is using his hard-earned money, what he has amassed during his 20 or 30 years of hard labor. So, just like my friend has said, this is just like Justice Mushtaq himself has said. He appointed me as the settlement. Yes, I still say to everybody that if it was before any other court, which goes by the rule alone, which goes by the mandate of 226 alone, this repetition should have been dismissed. But by appointing this, adopting this way of mediation, finally, the building has come up. It is a 2 twin towers with 17 floors, with 142 apartments and a commercial space. One of the beautiful places in this Kochi city, prime location near Kakana. This building, when I went there in 2019, almost August, September, it was abandoned project, full of dogs, snakes, everything. And in this process, the main complaint was raised by the people who were residing here. Because they said they cannot live there because of these dogs and snakes. At least the property should be clean. So in this process, actually there were 4 stakeholders. One was the builder who could not complete the project for various reasons. Second was the investors who invested huge money. Third was the financial. It is a government of Kerala undertaking which has invested money into extended financial. Because these builders owed around 15 crore rupees to this financial. And the fourth was the public who were also affected by this present situation. So we first tried to settle the dispute between this financier and the builder. It was brought down to 9.5 crores. Through installments, we are trying to pay. We have almost paid it. Only what remains is regarding some dispute regarding the interest. And the members of our investors is concerned. The main problem faced in this situation is the trust of the investor. When the chief settlement officer, I was assisted by 2 other officers, Mr. Shiraz and Vidya. When we have got the stamp of this court, these investors or the people who have invested money were willing to further invest. But if I go as a person and if I tell them that I can manage this thing, nobody will trust me. Only because of the authority of this court. With the stamp, they invest. And we got some apartments which are unsold. So we solved it also. Only few are remaining, 2, 4 or 5 of them. So with the stamp of this court, we could do wonders. The only thing is that we should understand how the people are affected because of certain situations and how we can bring in a resolution. That is why I said the mediation can bring wonderful solutions. That may not be permissible in law, because parties are not concerned with law at all. When a party comes to you with a dispute with another, he is concerned only with the dispute. He is not bothered about CPC, evidence, CRPC or constitution. He only wants to see that it is settled. So when the subject itself is lawyers' role in mediation, I may say, just like in other countries where a party approaches you when you send a notice to the other lawyer, initially there will be having some mediation effort from the lawyers. But here the Advocates Act or any other enactment does not permit it. We can do that, but we will not have any authority. So when the mediation set of law is to be framed in this manner, the first thing is to be ensured is that as an initial stage, just like in family disputes about a pending or conciliation or whatever, the lawyers also should try to have a resolution of this. Because personal disputes can be solved easily. There may be certain things which are interpretation of law and let it be done by the judges. But other thing we can resolve it. By resolving such a thing, especially in commercial aspects, no companies want to remain as enemies. Every company or every businessman only wants to believe that the dispute is settled and they go forward as such. So in the mediation process, that is possible. Then the one apprehension raised by the lawyers, that is also most important. Because I have witnessed, I have many experiences also. Because in a matrimonial disputes or any other disputes, when we come to this court will find out a solution or we will be sent to the mediation. And I have a feeling that as a lawyer who has been practicing in the High Court, I have a feeling that on many occasions, the lawyers who are appearing before the lower court are not willing to go for a mediation. Whenever we say that we can have a mediation in the High Court, they will say, sir, so many reasons. The basic reason is that when the matter is settled, the interest of the lawyer, so far as he is concerned, is not protected. Because lawyers survive and they live on, their livelihood is the fee received by the client, from the clients. So it is also to be protected. So if that step is taken, based on whether it is based on the amount or whatever the modalities one can decide. If such a step is taken, and lawyers are also made to believe that it is their duty to see that disputes are resolved, lawyers shall not try to say that the cases should go. No. We are fighting for the client's solution. There shall not be any fight at all. Because if you say when Purana says when Kauravas and Pandavas had a battle, they were about to have a battle, Sri Krishna went as the mediator. So every attempt should be made to see that disputes are resolved at the first instance. If such situation, such circulars or directions come, that can pay much towards resolving the disputes, reducing the number of pending cases, etc., etc. And in these type of matters, as my friend was saying, when we were appointed as persons to look into these things, we got the advantage of the stamp of this court. And even thereafter, apart from the disputes with the parties, we had many disputes with the authorities, statutory authorities, the panchayat, municipality, fire. All these officers will come up with so many objections. And every time, I am much grateful to this court, much grateful to Mr. Justice Mustar for helping us. Because even when we have all the papers with us, even when there was no objection, unnecessarily these officers will drag home in this thing. But now, with all these orders, armed with all these investigations, armed with all these orders, finally, the building is now there, it is standing as an icon for what mediation can achieve in the construction.
There are two instances which are similar in nature. And what we all can certainly see from this is how a very neutral person, not really conflicting persons, their interests, got them literally collaborate among themselves and find a joint solution for both their benefits. Now, this is something which we always see in mediation. There are times when people take absolutely rival stance. Originally, when the dispute came in, it was actually I versus you. And then I wonderfully brought from I and you to a problem that is faced by OD. And then he got it converted to such a situation where it is our problem and we alone can find solution. Now both of them are, they say they did not have any mediation training, but something which is certain is there, and they are inherently by birth, they are mediators. Now the talents are coming probably because they have also been cooperating with the mediations which have taken place, at least for their clients. They would have watched how the mediation process takes place. I got some kind of an influence or some kind of lessons, I don't know. I mean, would have certainly inspired. A couple of things that we found in those were, it will have the lawyers, not in this particular.
Okay.
Yes, so you had from both sides.
I had lawyers on outside.
That probably you did not mention that for us.
No. They were a person.
They were,
Yes.
yes, fine. Certainly it are coming. I did not see them when mentioning. The worst of the task that you would have had was to say how they would approach the whole problem to resolve, for which they would have certainly a chart or certain terms which they would have arrived. They would have seen that you would have had certain checks when you prepared this. And I'm sure they would vote. Who will do what? All right? You would have meant, so they did not explain it. Who would do what? For whom you would be doing? What are they going to do? Each step. When would they do the next? How are they going to do work and the manner in which they would do? They would have certainly prepared a chart. Am I right? Unless they come into this kind of a settlement, or at least, like jotting down what they would do as part of their consensus, it would have been very difficult. Now, here is a case where they had decided, they had actually compromised, they implemented it also. Did you need the court to further do something? Now, okay, so what is settled? Assume a situation where the matter was supposed to be settled, but the implementation was to be left over for the court's order. And the court was to implement, and they would have only come to a mediation settlement agreement. All that they did, all they chartered, will have to be prepared, signed by the parties, and handed over to the court. One error in writing something which otherwise the court would not have enforced would have literally blocked the whole result. It would have gone totally unimplemented. It is at these stages that we normally as lawyers would step in, certainly assisted by guiding as to the perfectness that you have or perfection that you have in the terms that you draft. In such a manner which would be understandable to someone who is responsible for establishing or for implementation. And the person who is going to implement is going to be a judge who understands judicial language. And therefore, it is the lawyer who is from both sides who will be contributing in preparing the terms, who would also be knowing the language of the judge, who has also got experience in how the technical terms would be, who will have their most important role in contributing such of the clauses which should have gone into the agreement. There's just one example that I wanted to say. I would, since the time is getting over, I would request Mr. Johnson to address you on the other technical issues that you would find when he mediates a construction issue. Johnson, please.
I don't think the timelines are being crossed or anything because I'll be as brief as possible. Today I stand before you to talk to you about the role of lawyers in construction mediation. As lawyers, I believe that if you are interested in practicing in this particular area, it would be beneficial that you may visit the site. This is FIDIC contracts. FIDIC is an organization which has brought out several standard form contracts relating to construction, civil engineering contracts, electrical contracts, turnkey projects, contracts relating to turnkey projects, and so on. If you are new into this particular field, it would be beneficial that you go through these standard form contracts. There will be three players. One will be the owner of the project, the contractor, and there will be an engineer. And this entire contract document will be discussing about the roles of these three players. An understanding of these three players will be very important for you to venture into this particular area of practice. Be it mediation, be it arbitration, or be it litigation. And I would also suggest another document that you should definitely verify. That is the Society of Construction Law Delay Disruption Protocol. It is a protocol relating to contract management, and you will find 22 principles relating to delay, disruption, concurrent delays, and acceleration. Acceleration in the sense that a project is expected to be completed within 1 year, and suppose the contractor accelerates it, what is the benefit that he gets, and so on. You will find these principles very important. When does a delay happen? What happens when a delay is, whether he is entitled, whether the contractor is entitled for extension of time, what is the other requirements for getting an extension of time, what is disruption, and these are the core principles contained in this contract. I am not intending to take you through all these things, but these understandings are very much important before you advise your client in mediation, because at the end of the day, the client actually works on your advice, and if you need to correctly advise them on figures, at the end of the day, every mediation ends up in certain figures, and at some point of time, random figures are thrown at you, and you will have to correctly estimate whether this is beneficial for our client or not, and advise him at that point of time. So as to do this exercise, it is better that you have an understanding regarding these two documents. One is the FIDIC standard form contracts. You have read books and other books by which they are called. And you need to also to understand the protocol that has been prepared. It is 2017. This Society of Construction Law has again reviewed it. So this is very important because it is not like construction law as such. I will just explain. Construction law you don't find in your law college syllabus, because construction law is something like an amalgamation of contract law, tort law, project management, and some amount of engineering. So all these things brought together is what is called construction law in India. I don't think that these are being provided in this. With this, I don't want to take you to the nuances of mediation, because a lot of things have been said about this. But I have prepared a small presentation, so I will rush you through this presentation. And so One is and a lawyer is appointed as a gladiator, and his role is to fight for his client in the court. And changing this role seems to become very difficult. And obviously, in a mediation, he is expected to be a counselor. There will be a lot of emotions that is working out inside the parties. And you need to be a counselor, and you see the right hand side, you see a picture. And this person can streamline the entire thing in such a manner that he is prepared for this mediation. Lawyer is a person who can make it or break it. So he is the person. It's not the mediator who does the job. It is the lawyer who actually does. This is the different forms of mediation, dispute resolution that is available: litigation, adjudication. Adjudication, in the sense, it is not the normal adjudication. There needs to be a statute. Unfortunately, in India, we don't have an adjudication statute. In construction contracts, which runs over a couple of years, these adjudicators are appointed and they resolve the dispute within a short period of 28 days. So there needs to be a statute, and India doesn't have a statute to support such as we have an Arbitration Conciliation Act. As we have already discussed, it is 3 stages. The lawyer's role is at pre-mediation stage, mediation stage, and post-mediation stage. And I believe that most of you know about this. 5 tips that you can give the clients regarding mediation is that mediator should not will not pick sides so that he is going to be impartial. I think that is a spelling mistake. Be open-minded and listen to opposing counsel's presentation. That's very important. The listening something is a very difficult process. Maybe the other side, gentleman on the other side will be talking, which is a very favorable point, and just because you have an emotional what they call situation, you are not listening to it. So encourage your client to listen to the other side. Mediation are typically long. For instance, it doesn't have complete by half an hour or so. The person comes, he should be encouraged to say that it may go on for the entire day. Intense and emotionally taxing, and make him prepare for that. Mediators are not arbitrators or just judges. We need to explain to him, and the binding nature of his decision also needs to be explained. Mediation often is the best time for settlement. Other preparations is calculating the client's BATNA. I think that many of you may be knowing about this. BATNA means the best alternative to a negotiated agreement. Whenever the client feels that this is the opportunity and there is no other way out, then it is they will accept this. And therefore, explaining to him about the BATNA of the case seems to be very important. And during the mediation, I think that the lawyers need to have, they will be the only communication, because before that, the communication between the parties might have got cut. And the best person to communicate would be the lawyer. Understanding the culture of the opposite party and the business. Basically, we should realize one thing, that the people are not interested in understanding their rights and liabilities and things like that. They are into business. They entered into a contract and there is a dispute, and because of this dispute, they are before mediation, and they are basically businessmen. They understand the language of business, and it is very important that lawyers leave their what we call the code of rights and duties and all those things and talk in terms of business. And they are looking for some shared wealth. And we should be talking in that particular language. And if you are able to do that, you can be able to successfully bring out settlements. understanding the culture seems to be a very interesting topic. Because in southern Kerala, maybe we are very much concerned about documentation. We write documents, we make sure that documents are perfect and so on. I don't think that this happens in northern Kerala. Northern Kerala, it works in a totally different manner. They say that I believe in you, I am going to invest in you some amount of money and things like that. So people will have different cultures. Once it go out of the country, the culture seems to be very different. I have heard that during international arbitrations, if suppose somebody addresses the arbitrator as my lord or your honor, he gets offended. He wished to be heard that he wished to that his name be called, or rather than being addressed as your honor. It is not the case in India. So this cultural difference is one thing that we need to be very careful while negotiating. Then the other aspect is post-mediation stage. Before that, I will take you to a very small instance that I want to say. In a construction, insofar as a dispute relating to a construction project, what is very important is that you have some timelines. Certain obligations have been taken up by the contractor. Certain obligations have been taken up by the owner of the project, and there is an umpire who is called the engineer or the architect or somebody. So everybody is looking to see that we have a bridge to construct and just to be constructed within 365 days. This is the timeline in the contract. So if it is 356 days, you will see that in the protocol you will find that people will agree upon some kind of a documentation method. And this verification of documents seems to be very important when we reach a point of dispute. So how does this documentation actually happen? For instance, you have to complete a bridge within 365 days. So what is the quantity of work that has to go on a single day can be calculated very easily. So such documentations are prepared by the contractor. Contractor will say that I will bring in n number of workers, this quantity of materials, and such other things. So these documentations, evaluation of these documents will be very important before you prepare for the mediation. So looking at these documents, emails, which point that the delay happened, who was contributing to the delay, and all those things has to be gone into and understood by the lawyer before going to the mediation, because decisions in the mediation or proposals in the mediation will be thrown up any other minute. And there will be good proposals which would benefit you rather than going and fighting in this case before your understanding about the case, documentation, preparation of this chronological order, and things like that is really helpful. I don't wish to take much of your time, so thank you very much, and I thank all the organizers for. I think that I have not addressed before I started my presentation. I'm sorry for that, and so thank you for the opportunity. Thank you.
Johnson for explaining the various roles that a lawyer would have in the course of mediation. Given time constraint, I think we will have this is Kannan actually online for the next session.
Thank you all. Thank you for this wonderful session. Now we'll be moving on to the fourth session on online dispute resolution. May I now invite the guest for the fourth session, Honorable Mr. Justice E. Mohammed Mushtaq, President, Board of Governors, Kerala State Mediation and Conciliation Committee. A true visionary with a zeal to make dreams a reality. The team of Nirnaya is a brainchild of his launch. A key dispute resolution His Lordship's tenure as President of Board of Governors has seen remarkable and significant contributions to mediation and conciliation in Kenya. On behalf of one and all, I welcome Honorable Mr. Justice A. Mohammed Bushra to the fourth session.
I will speak after Justice Kanu speaks to you because Justice Kanu asked for hurry for some other program. So please.
May I invite Honorable Mr. Justice K. Kannan, former Judge of Punjab and Haryana High Court and Chairman of Railway Claims Tribunal. His Lordship was instrumental in establishing under the aegis of Tamil Nadu Legal Service Authority in Pondicherry in 1981, one among the first few mediation centers in the country. One among the first team of mediators in Chennai during the inception of court annexed mediation in 2005. His Lordship, as Chairman of Railway Claims Tribunal, has structured a system to assist the railway administration in identifying genuine claims and offering settlement without an adjudicatory process. On behalf of one and all, a warm welcome to Justice K. Kannan.
Do I start?
Yes, sir.
Justice Mushtaq, all the organizers out there, it is a pure privilege to be addressing you. I would have truly taken an occasion to come over to Kochi, except that I was there till about 2 days back for a 5-day long stay. And just as I was planning to return, when Justice Mushtaq was asking me if I would be able to participate, I said that coming back was a difficult thing. But then he held out on a platter that I could spend a few minutes with you all through an online process. This topic itself makes relevant that kind of an address. I would, if I'm able to help myself being noticed through an online process, you will also have a taste of what is it that we are talking about when we talk about ODRs. Because when we are talking about the role of lawyers outside of courts, that's what we were probably the previous session were talking about, the role of lawyers outside of courts in mediation. And this is role of lawyers just not there in the court or even the virtual meetings of what are possible. Originally, I was thinking I should be talking to you about what is possible in a dispute resolution, which is outside the courtrooms and which is in an online process. But look at the kind of statistics. I was moving in just now before we started this to notice that today the National Judicial Data Grid makes possible for us to assess that there are 44.04 million cases. That is 4,40,000 cases, 4 crore 40 lakh cases are there pending across India. And if you are talking about, therefore, online dispute resolution, if it should be only we are talking about arbitration and mediation, probably that will not be fair. When we have, that is a kind of pendency. How much of ODRs can exist within the court system, and how will it make possible for people to connect in various ways other than physical presence? I thought I'll also make a reference about it. We have 11.04 million civil cases. This is again 1 crore 10 lakh cases, civil cases, and as nearly 3 times that, when we are talking about 11.04, 33.3 million cases, again 3 crore 30 lakh cases are there in criminal cases. But Kerala and Tamil Nadu present a very different picture in the sense that there are more civil cases than criminal cases, only in Kerala and Tamil Nadu. Elsewhere, the criminal cases, like I said, the national average is 3 times more of the criminal cases to civil cases. I suppose we have a different method of responding to disputes, and we don't truly escalate to all criminal cases. Better for us, we'll pat ourselves on our back for what I see now. We should be truly examining something of what technology and the formulations are possible to be integrated into the court system. I was there, like I said, some few days back. I was truly charmed by the kind of things which have happened. It'll be carrying coal to Newcastle if I should be talking about how do you integrate so much of digital technology and information technology in courts, because you have perfected now a technique probably which will showcase to the whole of rest of India. E-filing system, of what I saw on that day, I was truly stumped that there could be persons working from home, and that there could be in real time when an officer examines the file, it will immediately ping the lawyer whose file has been there. And as he finds out whether there is any compliance or where there is a document admissible, inadmissible, all those things could be engaged through conversations on online process, was what I saw. There can't be anything better than what you have done. But then filing is one thing. Then there are other things, of course. The COVID taught us in so many ways several lessons. One of them was this online hearing of cases in courts, and it grew to be a hybrid system as well. The Chief Justice of India, I remember, he was speaking somewhere that eventually he was saying, we will settle down to a system which is a combination of old and new. There are cases which have to be heard in congregation. That's what he said, probably putting them both together. One thing for sure is that there is no looking back. He said that again. And we will have to accept the present situation and change your mindset. So I was seeing this again, even at the time of filing, you can opt that you can appear virtually. You can exercise that option there. So therefore, it makes possible for people to be appearing from home or from wherever it is, where you can go elsewhere. The productivity increases where you're able to secure access in ways which are not merely physical, also through online processes. Of all the countries, in fact, this is something which we will have to say, in spite of carrying the odium of having the largest number of cases in the world pending. There are two things we always do. Being in Punjab, whenever we find anything in deficit, we'll look to examples from Pakistan and we'll find we are better off. And there is another thing which we are also used to. Cite Brazil. Brazil has cases, more number of cases than what we have in India. So therefore, and there are examples. But then one thing we can see that during COVID, it turned out that the Supreme Court heard over 7,000 cases. These are methods to enthuse ourselves, rejuvenate ourselves to thinking that we can really do well. We heard about 7,000 cases and delivered about 670 judgments during the COVID period. In comparison, the UK Supreme Court had heard 10 cases. Australia had heard 94 cases and pronounced 12 judgments. Canada had heard 17 cases and delivered 5 judgments. South Africa, 51. Singapore, 146 and disposed of 98. Spain, 800 cases. US had normally a light case load that will now take up only about 100 cases and odd for disposal every year. During that period, it was exceedingly minimal. So therefore, look at that. We have been able to devise methods of disposal through online processes, which are truly efficient. I was thinking when we talk about ODR, some innovations of what we can make is what I thought I should be telling you, because I will not see ODR to be merely situations where we do mediations or arbitrations online, but also within the court system. How do we do that work, increase the access? Some ideas of what I think which will give themselves effectively for online processes. For instance, bail and anticipatory bail. Do we all not know that taking a person inside on a Friday evening, and so that, you know, Saturday, Sunday will not be days where a person can apply to bail, it's a police tactic. And we also, many persons who are advising their clients to file FIRs and take a person in. We have a method of having the last laugh. This person is going in 48 hours, he won't be able to come. If he's a civil servant, he's gone. Surely through the conduct rules, it provides for misconduct, and then he will also be visited with surely a suspension. So therefore, to prevent this kind of situation, perhaps these bail applications, it should be possible for us to be listing them probably from the magistrate court upwards to the district court, to the high court, to up to the Supreme Court. Matters of for the High Court and Supreme Court, if you should ask me, what is it that the High Court is meant for? What is predominantly a Supreme Court meant for? I would think personal liberties are the most predominant concerns. It ought to be the predominant concerns. A constitutional court which recognizes the personal liberty is doing justice to itself, its existence, and how the constitution makers looked to these courts as providing the utmost comfort for persons that they are not detained in ways which are against law. Therefore, the habeas corpus jurisdiction of what we have. So I thought, even apart from the High Court or the Supreme Court, some method of increasing the number of hours, or probably making the access possible through ODR applications in these matters like bail and anticipatory bail should be an ideal thing. Course of time, probably it should happen. Speaking of innovations, then I also knew personally of Justice Mida, who is now retired. Even before COVID, they used to taking judgments through pen drives. So somebody arrives there and gives a pen drive, sir, this is all I have to say. You'll take it. You'll not make a fuss about it. So therefore, when I'm saying online, I would even assume that any form of digital technology, to the extent it's possible, which can save time, space, all those concerns can be addressed if we are able to make possible new methods of presentation of cases. And if I should recall my own experience recently in cases where court-referred mediation cases, they can be fully automated. We have, as I see in the ODRs, we have 2-3 persons who want to show hands-on experience of what is happening. I've had occasion to do some cases for Bombay High Court. And thanks to the online platform, and this is on a regular basis where I see. And therefore, I thought I'll let you know about what kind of contacts are possible. And there was a party connecting from Taiwan through the council at Mumbai. The respondent was the party in Delhi with the council from Delhi. And I was a mediator at Chennai. And the case was being instituted, was going to be instituted. It was a commercial court case. And therefore, under 12A, the case had come through, had to go through a compulsory mediation effort. I found unbelievable flexibility of approach and how efficiently we could turn out talks quickly in succession in 2-3 days, in 3 hours each. We concluded the matter. So I was thinking, if Mumbai has been in the forefront in promoting ODR, I notice already with a dynamic judge like Justice Mushtaq, he has already, I think, empaneled some of the ODR platforms strictly for mediation. All court annexed mediations can go online, at least in commercial cases. Commercial disputes cases where you don't need to really know the body language and things. So much is consumed through documents. They give themselves so eminently suitable for ODR platform. So therefore, matrimonial matters and other things where emotions play a big part, and you can be together. There also I've seen across the world, there are various approaches. For instance, in the East, in New York and other side in Washington, and they all prefer to sit in separate rooms. They can't even suffer each other in the same room. But whereas the person led by Friedman, another person, the Western part of USA, more people are encouraged to sit in the same room, where persons can't even sit in the same place, see them in the screen in safe distances where nothing can come, nobody can come to harm with the other. I think it will be appropriate court annexed mediations that can go through ODR. And particularly also, you must have seen yourself that we have a case, there is a case, your cost list will be going. You'll be watching it at all times. Is the case coming or not? And suddenly you'll get up, if you're a mediator, you'll get up and say that he is going. If she's a counsel there appearing for one of the parties in mediation session, and that person will say, my case is coming. So please have it after some time. Now you can fashion all your hearings outside the court hours at any time you like, wherever the party is. So this kind of a flexibility of approach of what takes place where parties are situated in different places, it can truly be an effective thing. So then again, I also see that many high courts, the Chief Justice normally shoulders a lot of administrative work and has a light board at least on Fridays. And that is when you have the arbitration conciliation section 11 petitions are taken. Of course, now more and more courts have the delegated powers to some other person apart from the Chief Justice. But then this is again fairly light. Like in the Supreme Court, the transfer applications, interstate transfer applications, matrimony matters, they get to be taken by a single judge. And there is hardly anything. They'll see where the party is, where the wife is, who can travel easily, then make possible transfers. But then imagine if we can connect to all those cases. There was even a judgment with Justice Adarsh Goyal saying that in all matrimonial matters, it can be through online processes. There was some judgment like that in 2018. So therefore, we should be easily able to adopt this. I was telling you, I'm coming towards the close. I know everyone has 15 minutes. I thought that this I must share with you. 5 days of pure excitement was what I had in Kochi. About 70 odd people had congregated there. These are persons who were interested in integrating artificial intelligence systems in the cause of law and justice. This is organized by Maker Nyaya Residency 2023. This is what they had called the workshop as. It featured days of intense building or crafting innovative solutions to the problems of law and justice. In fact, these are the entrepreneurs, innovators. They delve deep into their own ideas, prototype them, receive guidance from a set of mentors. I was there trying to validate them, what can stand in court, what cannot be accepted in courts, and things like that. When we talk about making ODRs work well, I should tell you about one person who was who I truly, it was exciting for me to be seeing. Justice Mushtaq also had kind of a short talk with him. He was a young IPS officer. He was from a sub-district from Visakhapatnam. He's IPS. He has a bot. He is himself a BTech engineer from Kharagpur IIT. After that, he has done his IPS, civil service, joint civil services. Therefore, he has technical knowledge. He has worked an application where anyone who has issues of harassment, sexual harassment or sexual offenses, where they have a problem about having to police stations, they can immediately launch their complaints or ask questions whether this is harassment, is it bad? So where there is a person who is in doubt, is this correctly happening? This person is stalking, still not anything physical, but I'm worried. What kind of protection I can obtain? These kind of things can go. And even if the police has some doubt about how to handle a particular case, he can also write that through bot and through, it's just a mobile application. You can get responses and the machine learns itself to say what it can deliver. In fact, we were also at that time, Justice Raja was also there, Justice Mushtaq was there, and there was a small group of persons who were showing to us how even if you have the pleadings already made, that you don't leave it to machine to make. But then if there are pleadings there, you don't know how to articulate. You don't know how to identify the true points which have to be pressed, and then what can be given up, what concessions can be given. It can generate arguments for you based on identifying the issues. These arguments, if you polish them by your own additional things, how do? You can kind of think what are all the enactments which will be applicable to that. You can say something like a contract act, and then you also think specifically fact. You also think the law of damages on some issues with reference to some sections. So all these kind of things, you merely input them. It gathers the case law and then collects it and then puts it up for you. And then points for arguments are made. and then it prepares arguments for the claimant, it prepares the argument for the plaintiff, for the defendant. So you can polish it and the machine learns it. The next time when you give somewhere close to that, what all it has to see, it learns itself and then gives that. Imagine how it can help even a judge. It happens, I must honestly say, there are ever so many occasions where you find a lawyer is not fully prepared or probably is no match to the other side. So kind of put the person in equal measure. You can run through the system or probably advise if it's all available. You can create that. You can help yourself to better preparations and it can work. So that's one area where I thought what artificial intelligence can do. In fact, there were so many other things which we saw. For instance, if you have come that far, translation, a seamless translation. This is all, it's an open AI. It's available for Subhashini is the program which is available there, created by a team of persons led by Vivek Raghavan, who is a part of Nandan Nilekani's team. I was there in the Supreme Court AI committee to suggest some changes. And we had worked on some programs. That program included, the first one was translation. We translated just not the words, but the sentences themselves. More than 2 lakh sentences were taken for apt translation. Now, it's our experience, probably Kerala was amongst the first courts which made all the judgment available from Malayalam to English, English to Malayalam, all that was available. I've seen it in paper as well. But imagine, take it to the next stage of what a person gives as evidence. It can be digitally transcribed if he's speaking in Malayalam, and if the judge is a person who does not know Malayalam. For instance, the first court is invariably a person who comes from another court. He may not be acquainted. Or imagine again, some courts like Madras High Court, the language of the court is English. Of course, even apart from a few states, 3 or 4 states, most of the high courts have languages only in English. And where the preparation of the typeset has to be made, we have to have it in English. For instance, a criminal case, a referred trial matter. Those are cases when they come on appeal. It's a big compilation. And seamless translation is possible now. And even transcription of evidence, if a person gives evidence in Malayalam, it can be immediately translated in English and transcribed in English, and then it can make available. Transcription is a facility which I have had occasion to use and never get any witnesses from outside. See, when I'm talking about I have used, the idea is never to say with any I being important. It's sharing an experience. If I can do, anyone can do. That is the way I would look at it. For instance, all arbitration these days I've connected to parties from Singapore, Malaysia, without having to secure their presence here. And there are arbitration centers there, SIAC is there. They immediately make available for the purity of evidence and integrity, that no prodding and any kind of prompting is given. They secure the place in the presence of an officer. Same way in India, I've taken personally assistance under section 27. I've taken assistance from Bombay High Court, Rajasthan, Allahabad, Delhi, Punjab and Haryana, Calcutta. These 6 courts I have spoken, and any evidence I have to bring to court, to arbitral proceeding, I will immediately write, and these courts have extended the facility of making the person come to the ADR center, give evidence from there, so that there is internet connectivity. And thanks to 13th Finance Commission, many of us know that almost there are 750 ADR centers across India. The nearest district court is where the party has to travel, whatever is the distance. That's all he has to travel from any place to any place, and evidence can be recorded. Court suddenly can improve the performances by quick translate. Otherwise, we know what happens in courts. A question is asked, a judge translates if it's a local language, translates into another, and dictates to a stenographer types it, then it's taken. But here you can keep going on with your questions, and it can bring about, I've seen in any one day, we'll have somewhere close to about 250 pages of transcribed material. Of if it would have taken 5 days, it would be completed in half a day or 1 day, in about 6 hours time. So this digital technology and this online process of transcription is something which is extraordinary, which we can really work. I'll conclude it with one thought of so much of what is happening, of how much improvement we can bring about in our systems that can take place through new techniques which are available. Even if it is not, in fact, there was another area which we saw. This is also was showcased to your judges there, and Justice Mushtaq was there to see this, that where you can simply upload a document. You can upload any number of documents if there is a PDF or file. Only thing is, it has to be computer legible. Therefore, if you write now, you have all gotten used to it now, that you can't have handwritten things. You need to put it in a way which is properly taken in a computer legible language, and it can capture. What we did was for the working for the AI committee, we fielded somewhere close to about 175 questions, test questions. For instance, in a criminal case, that's how we worked, and took Jharkhand as the area. If it's a case of, say, 302, who was he last seen with? What time did he go? What is the kind of past? What is the motive between them? What was the weapon used? Is this weapon sufficient to cause that injury? What is the doctor's evidence about that? When was the person apprehended? Who recovered that article? The kind of questions like that, we made some 175 questions. And you can immediately, as you ask a question, it's picked up, and it will show out in a separate window. You can see immediately, and it will improve the questions. So we'll be able to identify any case. You can make any category of cases from a large volume of 2,000 pages, 3,000 pages of data. You will have answers at the touch of a finger, no time lost. So these are things which can work on an online process where wherever the party is, wherever the evidence is to be given, the technology can make things work in ways extraordinarily. And I don't think there is a whole new community of people in villages who may be finding it difficult. I told you about this Kishore, the person, the IPS officer, I didn't give you the name. He is able to make people from villages connect. What is the difficulty that we are going to have? In fact, I've also seen telemedicine in Chandigarh when I was there as a judge. So many people used to obtain medical attention from the PGMR at Chandigarh, from various villages. And people will come and report, and there will be a doctor at Chandigarh who will give the method of connection from a lot of taluks have the internet connection with video facility. All that will become possible. We shouldn't be creating tech savvy or only there in cities. They are in towns and villages who are effective. Increasing access is perhaps the key. Increasing access through technology, what has come to stay, is something which we cannot miss. I'm sure with the kind of fillip to activities relating to information technology and its application in courts in Kerala, you have something to surely show to India, the whole rest of India. I'm so proud to be associated with you on this day, because I've seen how you are performing there in your courts. It's a little more, you'll be able to scale up in a way which no other court in India has done, and you'll be setting the agenda for rest of all the courts. Thank you very much. These are few thoughts which I thought I should share with you. I close.
You may use something and start your presentation.
Good evening.
Good start.
Yes, sir. Good evening, everyone. Firstly, thank you so much for giving us this opportunity. Justice. I'm slightly nervous because we started in 2015, and I remember at that time when we were going from courts to courts and speaking to lawyers, judges, talking about ODR, and we were ridiculed, we were laughed at. We thought, this is something absolutely ridiculous what we are building. Actually, we resolved online. But we had that belief, and that belief came in because of our own personal experiences with litigation. We saw in our personal and professional lives how litigations were going on for decades, and there was just not any resolution which was coming out. And that's why we realized that concepts like mediation, arbitration, of course, they can be used as an appropriate dispute resolution mechanism to resolve it. And if we infuse technology, it can just make it much better, much quicker, and much more convenient for parties. That's where the journey began from. 2015, we got our first case. It was a MACP matter which was going on in the courts for 5.5 years. And within a span of 30 days, we were able to resolve that dispute. And that lady, I yet remember, so I could relate with what Mr. Panchu was mentioning, that parties are always there to pay if you are providing value. And that lady was coming from a very poor background, not able to run a house, and yet when she was able to get the amount within 30 days, after us doing this pro bono, because this was something with experience for us and understanding the learning, came into our office, she got an envelope filled with cash, and she was just not ready to leave without paying us because of the service that was provided. So that's the impact that ODR can actually have, and we've seen that firsthand. Fast forward to 2023, there are lakhs of disputes that have been administered on our platform. We've been able to scale it up really well. So ensure that we work with various other stakeholders apart from disputing parties to ensure that ODR really moves forward. And I feel extremely honored, sir, that in the new Nirnaya scheme to ensure that ODR becomes a part. Thank you so much for this opportunity. Now, just to briefly talk about what exactly we built, right? So it's an online dispute resolution. That the entire process happens in a manner with limited efforts and from the comfort of your homes and offices. So 24/7 digital access. The vision was to ensure that there is access to justice, and that is done digitally from the comfort of people's houses, and that's exactly what we've been able to do. It's a completely sustainable approach. You don't need any paperwork to be involved. All the documents stored on the platform. Yes, as sir was mentioning, that even in the remote areas, if parties would have to come and participate and come to court for them to do so as compared to them doing this from the comfort of their homes. That's exactly what we've been able to do. In terms of recognition, we've been enlisted by the Ministry of Law and Justice as an ODR. We were the first ODR institution to even get recognition and empanelment by the Bombay High Court. Justice Karan was there a few minutes back, and he spoke about how Bombay High Court has embraced this, and we've been able to see a great success when it comes to how online mediation has worked and when we happening traditionally. And that's what led to
even the High in this fact, and we were able to conduct a judicial training for some of the judicial officers. We expected about 100 or 200 to join because this was a voluntary training which was given. And we were surprised, rather shocked, that there were more than 3,000 judicial officers who were part of this training. This got a lot of media attention. A lot of other district legal services authorities also started reaching out to us. They realized that this is a problem which is massive, and if a platform like this could help, it would really ease the burden also. So that's something that we've been able to do in terms of the panel of mediators. We've been able to get a diverse panel. It's not only people who are practicing advocates, but even chartered accountants, even engineers, surveyors who are a part of our esteemed panel at the moment. And we have a very stringent policy to panel mediators. There's a test or entire criteria for you to be empaneled. But once you get empaneled, you are able to get a lot of cases, and this is not only from the courts, but even from private mediations that have been happening through our platform. Also, when it comes to policy, jurisprudence, Sir has spoken about how ODR has really been embraced by so many other stakeholders, regulators, businesses, and that is something that we played an active role in creating that excitement, that jurisprudence around ODR, and we've been able to deal with a lot of policymakers to ensure that this moves forward. Now, when it comes to process, right, like how exactly ODR works. So a lot of people do have that confusion that probably ODR would be just arbitration or mediations done online. So a Zoom or a WebEx would do. Why is it that you need a platform? But that's not the case. That's just one of the applications which can actually help in engaging communication. But before that, there's a lot of things where automation takes place, where there is use of artificial intelligence, there is use of various technologies that ensures that the ease of onboarding and the transformation happens very simply. So typically, when it comes to the process flow, any disputing party, they just have a simple form which can be filled on the platform. Once the form is filled, the appointment of mediator happens automatically. Now, this happens on the basis of certain parameters which have been laid down. Parameters are, of course, on the basis of number of experiences, the kind of background the mediator has, the subject matter expertise that the mediator has, and accordingly, the mediator gets assigned by the platform. There is an established communication flow which is ensured between the parties. We have integrated WhatsApp, email, SMS. We've also integrated IVR calls. We ensure that IVR calls go in different languages. So depending upon which state the person is from, the language can be selected at the time of registering your dispute, and accordingly an IVR call will be going to that particular person to ensure that they understand what the mediation process is all about. When it comes to, of course, the entire focus of building this platform is to ensure that there is amicable settlement that takes place through our platform, and that has been the focus area so far. When it comes to the pre-institution mediation, right? So as I mentioned, we as an ODR platform are empaneled by Bombay High Court, and we've been able to see 100% success rate until the recent past, where there were few cases which led to failure. And that's where we've seen an 80% success rate so far with all the cases that have been referred to us. If I just speak about the numbers, traditionally, if it would have been done, the numbers are in 55 to 60% range. So they've definitely seen that the success rate has gone up. The participation has been much more as compared to offline. Now, what are the features, right? So as I was talking about ODR, and it's not just video conferencing, which is done online. So we also ensure that at every step, every communication that happens through our platform, there is real-time tracking. The mediators are able to see when the particular invitation to mediate or a document which is uploaded, when the person has actually read that email or read that WhatsApp. If there is any response that comes to us, that also gets auto-triggered on that particular case in the dashboard. So that's where they are able to see that on a real-time basis, the case status is updated. There is speech to text, feature which is configured. Now, again, why this is important? Because a lot of people who may not be very comfortable in actually typing out what exactly is the dispute about, or there are times where emotions are involved and they would not be able to really use that as a facility. This option is also available where they can just record their message automatically. And again, even if it is done in different languages, there is auto translation which is available on the platform, which can be easily used. There are templatized formats, especially for mediators. So there's a lot of admin related work for mediators, which can also be automated. That's where they've been able to see the ease when it comes to conducting mediations online. Smart negotiation chatbots is something that we are building on. We are at a beta phase right now. We've seen that with some private mediations that has worked well, especially when there are pre-approved offers which an enterprise would have, and the other party would be able to participate in that. The entire process, as we mentioned, because it is sustainable, it is because of the fact that there is e-signing, e-stamping facilities which are also integrated into the system. You don't really need to, even if it is a settlement or if it is a failure or if it is a non-starter, it's not that you need to actually take a printout and then put up your signature. You can do this all via the platform digitally. Now the benefits, I think this is something that all of us have already spoken about. A lot of other dignitaries in the previous sessions have also mentioned the fact that how if we use technology, we are able to ensure that there's more participation. Even people from remote locations are able to access the platform. That makes it even better for us to ensure that the digital access to justice, the vision that we have, we are able to take that forward. We also ensure that there are automated and regular reminders that keep going to other parties. There are features where even if the parties would want to share a document only with one of the parties or maybe only with the mediator to ensure confidentiality, even that option is available. Just have to click on the name of the party or the mediator and click on send. You can bulk download multiple documents. You can bulk send multiple documents. You don't need to individually do it if that is the case. So all those features are also built in. I think eventually what this would really do is how we can reduce the pendency. That's the focus of this entire scheme, which has also been built in with your leadership, sir. And that's exactly what we also envision, that how we can reduce the pendency, how we can work together with courts to ensure that there is more acceptability for ODR. Now, again, one more thing with Mr. Panchu mentioned about success stories. I think this is something we genuinely believe that should be spoken about. I think the first one, Justice Kannan already spoke about. We were fortunate enough to have him as a mediator in that case. And this was a case where the lawyers were not even expecting the parties to participate because of the fact that how the case was so complicated that though it was just a prerequisite because due to the PIMS rules, you have to go through pre-institution mediation. It was just a tick mark which they wanted to do, which was clearly stated to us. But just the first meeting, so again, some of the dignitaries mentioned about pre-mediation, conversations or counseling. In this particular case, that is exactly what happened, and it happened with the lawyers. So it is extremely important that the role of lawyers is really appreciated. And I'll be absolutely frank, right? I mean, in all my conversations, whenever we speak about mediation, it is somewhere, we have become a little cynical when we talk about the lawyers being involved. But in our experiences, if 80% is the success rate, what we've been able to see for all these pre-institution mediation, one of the major credit goes to the lawyers. The way they have gone about this entire process, the way they have gone about educating their clients, and that's what have really brought parties together to settle it out. So in this, Justice Kannan already mentioned that the party was in Taiwan, the other party was in Mumbai. He was based out of Chennai, and within the span of 2 months, the matter was settled. And now what we are also doing to ensure that there's more transparency, more acceptability, we are also taking video testimonials of all enterprises or of people who have used our platform for mediation, because that's what will build more credibility. It will give the confidence to the parties that yes, this is working out and you don't need to come to a place, a common place to actually resolve your dispute. Again, another commercial dispute, approximately the value of 31 lakhs. One party was in Mumbai, other was in Rajasthan, and the mediator was in Lonavala. The mediator was actually, because of the lockdown being there, was in Lonavala, and she could not really make it to her actual place of residence, but yet the mediation did not stop. And even during the lockdown, we were able to see that the parties were able to come to an amicable settlement. The third and final one, which I thought would love to highlight, is the fact that it's not only when there are just two parties where mediation really works out. There were complex cases which were also being referred by the courts, which have empaneled us. And even in those cases, we were able to see that if there were multiple parties which were being involved, and the mediator was based again out of a different city altogether, they were able to get through the settlement. So the whole point about lawyers being involved, I absolutely concur with every single person who mentioned out here that how they play an extremely important role. And we've been able to see that in our cases which have been referred to us. And another thing, what we are doing with the judicial trainings that we are doing. So after the Bombay High Court, we got this opportunity with the Madhya Pradesh High Court, where we conducted this training again. 500 judicial officers participated in that. What is happening is that the awareness is being built. More and more lawyers are now reaching out to us to get empaneled with us. They are needing training for getting into mediation as well. And that is something that one of the aspects which we really wanted to explore, that how can we have partnerships with training organizations and these advocates or lawyers who are really interested, how can we ensure that we build a bigger and better pool of mediators? So that is something that I would love to highlight. Lastly, the collaboration, I think we already mentioned that there are different ways in which we can collaborate. One, of course, because of our platform being there, it's already built. The mediators who are being assigned these cases can use our platform. The other option is where the institutional mediation services can be used, because we have an entire setup. We have our own mediators who are empaneled with us. And the third option of, the number of cases are only increasing which are coming to us, right? Even from private mediations as well as the court annexed mediations. And if we are able to get more and more interested advocates to participate, to get empaneled with us, we'll be more than delighted to have this as an opportunity to engage with them. And then the final thing, if we can do a similar judicial training for the judicial officers of Kerala High Court, we'll be extremely delighted to take that conversation forward. So that's it from my side, and I'd be happy to address any questions if anyone has.
Floor is now open for questions. Thank you, Resort 360, for that very elaborate demonstration. Now may I invite representative of Jupitites for the online demonstration.
Good evening, everyone. I'm the Vice President for Product Engineering at Jupiter. And first of all, I would like to thank everyone present here, specifically Hon'ble Justice Mr. And of course the KSMCC itself for organizing this event so that we can be here and present our own platform over there. Secondly, so what we'll do is we'll start off very quickly from a very brief presentation, but then I would also like to give you just a little taste about how we actually work, how it functions, how to give you a sense of how mediation actually functions at Jupiter. So let's start off. First of all, Jupiter is a justice technology company. We are based out of Chandigarh, and Jupiter develops various platforms for various organizations. And we've been working on it. So we've been working on it since 2019, and we are focusing on things like judicial mechanisms, quasi-judicial mechanisms, ADR mechanisms, which includes mediation, of course, and even some police initiatives are also done by the Jupiter team as well. So the goal here is essentially to work with various people. We have our own marketplace of ADR professionals that involves mediators also. We have more than 3,000 of them. They've been vetted. We have a vetting process for the mediators. Even lawyers from over here can panel with us, and you will have your own elaborate profile, and everything will be considered. And as soon as, for example, the platform itself is concerned, so this is essentially the mediation process. This is a whole elaborate process. I don't want to go into a lot of details about it. But what I would like to tell you or take your focus to is the very beginning and the very end. That means the start and end of the mediation process, and everything that happens between each of them. Everything happens online on the platform. So as we've been discussing until now, technology is something that we can leverage. That involves not just traditional technology but also modern technology as well. So that those are things like artificial intelligence, for example. Maybe you have heard about ChatGPT. So we can leverage those kind of technologies into the mediation process to bring in automation, more efficiency, save time, save cost, and also automate a lot of these processes. So almost 50% of these processes can be taken out just through basic automation or advanced artificial intelligence-based automation through the Jupiter platform. How we do it or how we achieve it is essentially we have a system that is built from bottom to top. So, for example, we work with storage, and then we have a foundational infrastructure of technology. So the technology is there to assist the mediation process or even any other processes like arbitration as well. We have Lego block-like structures. All of the functions and features that any mediator might need, or any of the parties that are hoping to resolve their dispute online, any of the features that they might need, we have them on the foundational infrastructure, and then accordingly we can mold the process of the mediation according to individual case level. So, for example, it is unfair to essentially say that small mediation cases that range from thousands of rupees or maybe few lakhs of rupees have the same level of complexity as cases that range from few crores to maybe 100 crore cases. So the platform adapts according to the case requirements, the case structure. All of that is only possible because we have the foundational digital infrastructure in place with us. So we use that, we assemble the processes according to the mediation cases that we have in front of us, and then over on top we provide services on the platform. So those are things like, of course, case management. Any of the mediators from the panels can be taken up as well. So case management involves things like coordination, scheduling, notification, reminders. All of that is taken care of automatically to the extent that whatever it can be. And wherever is otherwise needed, people can always come and interact with the platform. And of course, the platform needs to be simple, it needs to be very approachable, accessible. So that is why we also have things like mobile applications as well. Or maybe you can do it on your tablet, on the go, your iPad, your laptop, anything. You can, if you have a internet connected device, you can use, you can be a participant in the mediation process. That is essentially the goal, to bring as many people as possible onto the platform. Okay, so that is essentially for the presentation. But what I would like to do next is take you through the process of how actually the mediation happens. Okay, so what we will do is we will very quickly look at how it functions. This is just a very simple thing. You can register it. Any person who has a dispute can simply fill in their very basic details, their phone number, their email, and that is it. They can simply go on. Simple verification is done, and then these are essentially a few different types of mediations that can happen on the platform. So right now we are looking at the commercial dispute mediation. They will simply click on it, and then on the left hand side, you can see the filing process has been simplified. This is to bring in more people on the platform, make it easier for everyone, and then we can go through it step by step. Some basic details are taken up. Even lawyer details can also be taken up. The details of the opposite parties taken. All of that is taken. All of this is done automatically, and finally, at the end of the very simple process, they can even make the payment online as well, and then they will be taken to their dashboard. So what we do is, okay, so how does this work? Every person who is associated with the mediation process will have their own account, their own dashboard. They can do all of the activities. So this involves things like looking at automation. So if you want to scrutinize a document that has been submitted, or any case manager might want to schedule a new meeting session with any of the participants, all of that can be done from the dashboard. This is just one of the examples of the dashboard. You can see, for example, the action board. So other than everything else on the platform, I would simply like to take your attention to one specific feature, which is this, my action board. How it functions is the platform uses technology to understand mediation, to understand intrinsically how it functions, what actions are done, who is responsible for doing what activity on the platform, and accordingly, the platform already knows what they have to do. So, for example, if a mediator has to schedule a session, then the platform automatically tells them, okay, the session needs to be scheduled. They can simply either go on their app, click on the button, and the session will be scheduled. If any upcoming session is coming up, someone wants to make any preparation, any submissions, the platform again knows that, and the platform uses the knowledge of the case, its process, and its progress until now to figure out what activity needs to be done. So this is done to push people gently into the, or rather nudge them into the direction of a successful settlement, which by the way would otherwise traditionally be done manually by the, for example, case managers, people who are making calls, making arrangements, sending reminders. Some of that can be automated so that the mediator only has to worry about the core of the mediation function and nothing else. So this is just again one of the examples of those things. Another example is, for example, so this is the mediation room that we have. So what is mediation room? Mediation room is essentially an online place where you host mediation sessions. And for example, on the left hand side, you can see a preview of me. On the right hand side are the people who are supposed to be joining this mediation session. So for example, we can see all the participants, the neutral, all of the parties, even their lawyers as well. All of those people are available, and we can even submit information. So for example, this is where we can even use AI as well to transcribe information. So as you can see, this is coming up in real time. So people do not even have to type it out, and we even have support for multiple languages. So for example, if you're talking about Malayalam, so it is also over there as well. So if we join the mediation room, we will land in a place with similar to this. Okay, so how this functions is, all of the people are in the room. This is, you can think of it a little like Zoom, but let me very quickly point out how it is different from Zoom. First of all, the platform is an integrated platform. That means all of the information is secure and the privacy of the person is maintained. So any information is not shared with any third-party company. For example, we are always worried about companies like Zoom having access to your personal information. That is not the case over here. All of what you see in front of you has been built by us, by Jupyter, and that ensures data security and data privacy. And even, for example, any hosting organization can host it with themselves. So even Jupyter itself will not have access to any of the data. So in today's day and age, data privacy and security are a major concerns, and this is just a very one of the very small steps that we've taken in that direction. Another advantage of having this is all of the mediation processes are integrated into your digital life. That means you do not have to maintain your physical file with you. No one needs to carry a file. All of that is available even during the hearing. So, for example, if anyone wants to view the appointment to mediator documents. So these are available during the hearing, which are automatically also generated by the platform. So this is again another way in which automation is brought in, and also document generation is also done by AI as well on the platform. So much like ChatGPT, in ChatGPT you can go and simply ask it to generate a reply, for example. We also have that functionality. The system will analyze all of the information that a mediation case will have, and it can automatically generate documents and information from the perspective of any of the parties on the case. So likewise, I also have access to my entire case record. So if I want to see any requests that have been sent, any notices that have been sent earlier, I do not have to organize them, I do not have to carry them with me, they are always available for me. Same thing is if I want to make any new submissions into the case, I can do it again. From during the hearing, I do not have to again maintain files or send them via emails and then maybe worry about having someone wrong in the email list who might inadvertently have access to the confidential information. None of that is a concern over here because everything is centralized. So that is essentially what we have for the mediation room. And other than that, so we always have things like screen sharing, recording of hearings. So with the consent of all the people that are involved in the mediation session, we can even record the session as well for later meeting. So that is essentially the mediation room. And after the mediation, what happens is this: what we need to worry about is all of the data that we have, and more importantly, how we can utilize that data. So, for example, what I would like to show you is essentially we've actually had the privilege of hosting a few local adalats ourselves. So the Justice platform has until now hosted more than 1 crore cases, and all those cases were on the platform as part of the local adalat initiative. And so, for example, this is just few of the information that is available. So we can even do things like geographic analysis. We can look at how it works. We can zoom in. We can see which areas are having which kind of disputes. We can do all of that. We can even look at the data. We can see or break it down on the basis of types as well. So, for example, if you wanted, you can look at, for example, on whatever date or month, the breakdown of the disputes on the basis of the types. You can look at that right in front of you. Another thing is, for example, okay, so this data can be correlated and then converted into actionable insights. So, for example, it is possible for various institutions that are using this platform to make policies or make changes to their policies according to the information that you see from analytics dashboards such as these. This is again some way that you can tweak your processes to make it more efficient, to involve more people, or maybe resolve the disputes even in a quicker fashion. Okay, so other than that, what I would like to just very briefly highlight is mediation is just one of the pieces of the entire puzzle. What I mean by that is the expertise that we have, it is not applicable to just mediation, but we also bring in expertise from other areas into mediation processes as well. So we have a team of more than 300 lawyers, and we worked in all of these processes that you see. So the reason that we have those lawyers is we can understand how market works, how processes work, how human psychology works. Because again, human psychology is one of the other major components in a mediation settlement. And the platform is tweaked and tuned according to the human psychology to make it more easier and also to make it more friendly for the people to access it. And so, for example, these are a few of the organizations that we work with, and we're also working with human as well, also World Justice Project and India. I think that is pretty much it. If you have any questions, I can answer them now. Okay. So we have a couple of ways of doing that, sir. If someone in the background needs a question, sir asked how do we authenticate the person's identity when they are uploading it or the documents that are uploaded. So there are a couple of different ways. If it is information like, for example, human identification like Aadhaar card, maybe or driving license, we can integrate with various common entities and we can authenticate it then and there. Secondly, otherwise there's human intervention as well. So we have things like auto allocation. We have a pool of people that are automatically allocated any kind of new pieces of information and then they will be responsible for manually verifying the documents authenticity wherever or however they can. That is if and only if it is not possible to do it automatically. The goal is always to do it automatically first and then manually as a fallback. Okay, so supporting for that we have case managers with us. So case managers are people that are responsible for doing these kind of clerical works and also making sure things like documents are not cut out, maybe scanning is not done improperly. That is one of the things. And second is the document relevant for us? Is it something that that is available with the participant? And also on that portion only, sir, we also have things like digital signature and blockchain. Both of these things allow us to verify the authenticity of the person and assign the person with the document. That means it is not possible for anyone to upload the false documents or claim it from someone else's account if we store some bits of information of it into the blockchain. So that is just another way of doing it. Any other questions?
Thank you. Thank you, Guru, for that informative demonstration. Now, may I invite representative of SAMA for their online demonstration. Representative from SAMA.
Hon'ble Justice in the House, respected dignitaries. Good evening to one and all. Thank you so much, Mr. Nasser, for this opportunity. Yeah, I'm your last 10 minutes longer to a tea break, but I'll try to ensure that we cover this quickly. But we request you to pay attention because there is some very fruitful information which you can take from this. My name is Francis Sinha. I'm a co-founder at SAMA. I'm joined by my colleague Ajitesh, who looks after government projects. I think Ajitesh and I were debating for the last few days what is a good way to demonstrate ODR. And we thought nothing better than stories and stories of real people from themselves directly. So with their permission, we will be sharing a few stories. The names are redacted, but we can see. So this is a story of Vikas from Jaipur. He had a loan default case with the ICICI Bank, and through an online arbitration, he was able to get a fair award from one of the arbitrators. He was grateful to the arbitrator and the case manager who provided support. So this is one story of ODR being used in the city of Jaipur.
There's this second story when we were working with Madhya Pradesh police. Police triggered a dispute between a husband and wife. It was a women help desk from Jabalpur where this dispute was filed, and our mediators were able to resolve it. And as you can see, when they were signing the settlement agreement, you can see the smile on their faces. And then this is one when we did Lok Adalat in Delhi 2020, when the pandemic was there. So the courts were shut. There were people who were waiting for some relief from this was one matter of MAP, and the person from Tripura was able to get the compensation from the insurance companies for a accident matter.
Yeah, so similar to this, right, we are seeing many such stories at Sama. Sama is basically an online dispute resolution platform. The Sama word comes from the four via Sam, Dam, and Ved. Sam means to talk and resolve, based on the mission of Sulchao Magar Pyar Se, which means resolve with compassion. We have been working since 2015 to promote ODR. We really believe if you can combine the magic of ADR with magic of technology, wonders can happen for the justice system of India. Primarily, we provide services like online mediation, online conciliation, online arbitration. We also work with legal service authorities in conducting online local adalats. Additionally, we also provide services like e-stamping, e-signing, and local management system.
So, as on today, we have handled around 2 crore 35 lakh disputes, and all these disputes have come from local adalats, arbitrations, conciliations, and we are able to successfully resolve 37 lakh disputes. These are some of our enterprise users who use Sama, like 50 plus enterprises, which includes banking, NBFC, insurance, e-commerce companies.
And additionally, we also do a lot of work in the public sector, which is judiciary. So we do a lot of work with Gujarat State Legal Service Authority, Rajasthan, Delhi State Legal Service Authority, Maharashtra, Bihar. Madhya Pradesh has 52 districts and 1,000 police stations. If you go there with a family dispute, they will say, you want to try online mediation first for 7 days, and you want to try settling it online. And Department of Consumer Affairs, and recently, last week, in fact, we saw Securities and Exchange Board of India, SEBI, also launching an ODR platform for investor disputes. So these are different governments users for Sama. Different kind of feedback we received from whether it's member secretary of legal service authorities to e-commerce companies also like Snapdeal using online mediation through Sama. This is all their pending consumer disputes. Consumer disputes have been pending for 2-3 years against that Snapdeal. You Google Snapdeal, it looks very bad on them. They refer the cases, and those cases got settled online in the period of 30 to 45 days.
Then again, feedbacks from Madhya Pradesh, where police officers, like we saw how it made life easier for people who have disputes. But what about the police officers who have to deal with certain disputes and they cannot just say no to it? But obviously, when they were given a option that they can actually file cases on an ODR platform and that a mediator, professional mediator can handle those disputes. So they were really happy when they can actually delegate what is not meant to, what is not meant for them to do. This is the platform, this is the screenshot of our platform, which handles from start to end everything online, filing, e-stamping or e-signature, whatever it is. And you can see there are clear distinction, who is the case manager, who is the neutral, who are the parties, everything at one place. You don't need to figure out where to go, where to navigate. You can also perform bulk actions like sending notices in bulk. So all those options are available.
The ODR platform brings the full journey of dispute resolution online, but I strongly believe that ODR platform itself is not complete. We have around 3,000 mediators, arbitrators in 443 cities, so fluent in 31 plus local languages. And I think I saw a few of them are here as well, and we genuinely love them because without them, a good ODR platform is nothing. It is just a piece of technology. That combined with the human effort of the mediators and the case managers, that's why we are able to handle so many cases. That's why people are able to come, reach a settlement. And what our message and request to the movers, as we see a lot of mediators here, is that do adopt ODR as a skill set. Look at online mediation, look at online arbitration as a side, as an additional career option as well. And I feel if everyone does that, I think we'll have more success stories. Thank you so much.
Thank you. Thank you, Team Sama, for that interesting narration. Now may I invite Honorable Mr. Justice K. Ramakrishnan, former Judge High Court of Kerala, former member, Kerala State Mediation and Conciliation Committee, and former judicial member NGT, for the concluding remarks.
Good evening, everyone. It will be a hard time for me to stand before you at 5 o'clock and make a tiresome speech. After hearing 3 sessions on several subjects, one thing I want to say is the very purpose of alternate dispute resolution. What is the importance for that? See, when people were making alarm about the pendency of cases in court, it was in 1987. Legislature thought that there must be some alternate dispute resolution mechanisms required for the purpose of controlling the pendency in court. That is how the Legal Service Authority Act 1987 was passed. But quite unfortunately, it has waited for its streamlining and implementation only in 1995. For 8 years, though the Act was passed, nobody was aware of it. Nobody was prepared to implement it. It is later in 1995 that the Legal Service Authority Act has been implemented, and people started doing Lok Adalat as one of the methods for the purpose of resolving the disputes. And I don't want to go into the controversies of lawyers opposing it, etc., but that was there. When every new system is being involved, there will be opposition without knowing their role in participation. That is the difficulty in understanding the system when new system is introduced. That is what happened in the Legal Service Authority when Lok Adalats were informed. But later on you found that it has become a success, especially in motor accident case matters, where cases are pending for a long time without settlement, or even for a small amount of compensation, they have to wait for years. That even the response of the people that there is a system available for them where they can get speedy justice, and that is one of the promises or the right that has been provided on the Constitution as speedy trial and speedy disposal of cases. Speedy justice is always required, but hurried justice should not be. But there must be a balance, must be there for that purpose. When the lower adults were found progressing in a better way, the Supreme Court thought that it is highly necessary for the purpose of having another mechanism by which you can go for settlement of disputes. That is how the mediation councils have been formed, and mediation has started in Supreme Court in 2002, and thereafter in 2005. As far as Kerala is concerned, it started in 2007. But at the time when it started, again there was chaos. Among the lawyers, there was apprehension. Whether by Lok Adalat, our work has been taken away, by mediation, we do not know what is our role in making the system in a perfect manner. As people thought that adjudicate, because we are deviating from the adjudication process to a resolutory process. How far are you degrading your own judicial system? That was the apprehension among the lawyer community when these alternate dispute resolutions formations have been made. But ultimately, when people were aware of it, that it is required, and the steps taken by the Kerala State Mediation and Conciliation Council and also the other mediation centers all over India, the mediation advocacy was introduced. That was one area where we were able to convince the lawyers that any alternate, and forget about that we are degrading, it is not. It is only improve the improvement of the system. Thereby, you can filter the nature of cases to be decided really by the court.
Because all cases which are coming to the court are not necessarily to be dealt with by the court by taking evidence, pronouncing judgment, or hearing long arguments, etc. But there are cases where court's time is required for doing a better justice. It is always required. Alternate dispute. I used to say wherever I go, as a member of this thing, it is not alternate. It is appropriate dispute resolution system which you can resolve. You can decide which is better for you. The court is always in the court of the lawyer, not on the court of in the court or otherwise. It is for the lawyer to decide whether it is a case to be go to the court or it is a case to be decided by the parties by themselves, involving themselves also as party to the proceedings. I am stressing involving themselves also for the party to the proceedings. If that is being done by them, there is no apprehension for them that this is going to happen, or it is going to be deterioration for their professional interest. From morning to evening, in the morning session, you had construction process, how the construction process can be brought into in mediation. In the second session, you have commercial disputes, where how this can be done. A lot of participants have participated and they have discussed about all those things. The third session, what is the role of lawyer? And the fourth session is the ODR, how the ODR system can be. And it come to the ODR, I put it in a lighter way. Even decades ago, Charlie Chaplin had thought about, and there was a film, if I remember correct, the name is Modern World. It was satirically criticized, but a strong message has been given at that time, because mechanization is anticipated some 40 or 50 years ago. Mechanization stopped. When mechanization is coming up, unless you equip yourself with the mechanization, you will be thrashed out. That is how now we are going for a digital platforms. There may be some difficulties will be there, even for myself. I am a total failure in it. In fact, I can admit it. But at the same time, I am not opposing it. Because merely because I am not able to converse with that doesn't mean the system is bad. You will have to equip yourself for the purpose of improvement and get into the stream that is going on, which is going to help the system in a better way. If you take it in that sense, ODR, if it is perfectly done, if all other circumstances are good, then it will be good. Otherwise, it will be as bad as any other thing. Because ODR system, as far as AI is concerned, it is being fed by somebody else. If it is properly fed and if it gives the proper result, if it can be reliable, nothing wrong in going for that. But at the same time, don't rust your human intelligence. Once you start rusting your human intelligence, you will not be able to differentiate between the artificial intelligence and the real intelligence. Real intelligence always pays. So, for the purpose of understanding whether the AI is properly doing or not, you must know what it happens. There. For that purpose, you will study it. Once you study it, you know what is going on, where it goes wrong, how you can rectify yourself. So, this is the area where you will have to equip yourself for the situation, use all the facilities that is available for that purpose. Another thing is, now Nirnaya is an area. Earlier, the mediation was intended only for court annexed mediation. Subsequently, when Mustak has started coming to the Board of Governors, he wanted it as to be expanded to others also. Community mediation was introduced. Thereafter, now Nirnaya is another area where we are putting forward the benefit of mediation to the society. How the mediation can be utilized for the benefit of the society. One thing you must understand, what is the purpose of litigation? To get a solution. Whether it comes from a judge by writing a judgment, having a binding nature, or by another method by which you can arrive at your own settlement. which is also equally binding on you because you are party to your own agreement. Can you go beyond that? Can you say that I have not done it? This is an area where mediation plays a great role because you are the masters of your own solution. Such a benefit you won't get anywhere. Even if you come for arbitration, arbitration is also called for adjudication only because parties are coming, they are submitting their submissions, evidence, documents are produced, arguments are submitted, except going to the court. The arbitrator is deciding the issue on the basis of the legal as well as the facts before it. In a conciliation, there also, conciliator also plays a role because in the mediation, though everybody was telling that you have got a role to suggest, etc. But if you go by the basic rule of mediation, mediator has no role to suggest. He can only facilitate the parties to arrive at a settlement. For that purpose, option can be created by getting the needs from them. The option also be created by them only. Once the options are created, then you will have a private discussion. In the private discussion, you put the options before them. Is it not better for you to agree for any one of it? Just Johnson was telling about Patna and Patna. Patna and Patna are what? Best solutions and worst solutions. Once you arrive at the best and worst, you can derive acceptable to us. Acceptable solution can be possible. That is the area where mediation is a success because you are the mediator, you are the arbitrator, you are the conciliator, you are the decision-making process, and you are the persons who are arriving at the solution. For that, what is required is you must come with an open mind when you are going for a dispute resolution. If you go in the positional imbalances, because it is difficult for a mediator to bring down the impasse cost on account of the positional imbalance, impasse that is being caused. Because unless you come down, you remove your ego. If you remove your I in you, because even your Vedanta also says, unless you remove your I and unless you feel yourself, self-realization is required for the purpose of everything. And that self-realization can be possible only if the ego in you goes. Once the ego in you goes, when it comes for a mediation, you can easily open up your mind. Because most of the time, the mediators are failing in their attempt to open up the mind of the parties who are coming to the mediation because they are coming with a hard mindset that they cannot settle it. It is very difficult to break that mindset. Unless they are able to break the mindset, they cannot make them to speak more. Unless they speak more, they will not be able to understand what they are expecting and what they can get. This is what the mediation is about. And you will have to understand about the mediation. It is not the mediator who is getting it. It is the parties. They will have to dilute their mindset. And they will come with an open mind that whatever be possible, we will cooperate with the mediator for the purpose of arriving at a settlement. If such an open mindedness is there among the persons who are coming there, everything will be possible. Nothing is impossible in the world. If anything can be talked between the parties, around because you can settle the storm in a cup of tea. Because once you offer a tea and sit together, everything can be possible. And especially in the construction sector and the commercial sector, I don't think that any businessman will be interested in prolonging the litigation. Once you prolong the litigation, it will only affect his reputation in the business field. Once he understood that, because if I come to a dealer, go for some purchase, and if I find some defect and point out to him, unless he settle it, word of mouth will go to society that if you go and purchase and you won't get the result. Because people are the persons who are going to assess you whether you are a person amenable for resolution. I won't say you will have to settle it. At least amenable for settlement. whether they will come down from their original position of technicalities that they are right, then everything is possible. That is the mindset that the business community, because what is the difficult for the person you are going for? If you are investing 10 crore rupees or 1 lakh rupees today, if there is a dispute between you and the other party is only in respect of 10,000 rupees, you get 5,000 today, you can invest in and get 1 lakh. But if you prolong for years to get this 5,000, you are not only losing this 5,000, the benefit that you are going to arrive by investing this 5,000 for future purposes also being lost. So this is the way in which the people who are coming for mediation, just like the persons who are dealing with the construction field and the business field, commercial field, has to think about the role of the associations in making their members to understand this. Because your agreement, everybody knows, 90% will be one side. If it comes to the court will analyze it and found that certain clauses are unconscionable, we cannot do it. Pay the amount. If you stamp and pay, you will pay it. But you understand that is one-sided. We will have to relax certain things for the purpose of an amicable settlement and promote your business. Then everything can be possible. So that mindset must come for the purpose of facilitating this nirnaya, for the purpose it was intended. Otherwise, any new process that is being launched by any concern will be needed only. It is a cooperation that is required from the stakeholders on these aspects. As regards the mediators are concerned, the mediators have a role to play in everything. They must update their knowledge. Whenever they are going for technical issues which are coming before them for the purpose of settlement, unless they know what is the intricacies of the subject that they are going to deal, they will not be able to deliver the necessity thing that is what is required for that purpose. So they must update themselves. And as far as the lawyers are concerned, as in US, see, when a case comes to the client, the lawyer is not advising, as Ramavan has said, there is a difference between lawyer and an advocate. Advocate is only intended for the purpose of undertaking case in the court. The lawyer is a person who is expected to give a proper advice to the client as to what is the pros and cons of the litigation and what is the situation, if it is available, whether it is favorable or not favorable. He must give a clear picture to the party. And he must also give an idea about the other systems which are available for the purpose of resolving it in amicable manner than going to the court in a shorter span of time. Once such an advice is given to the party and the party is aware of the available mechanisms, then they can resort to that. They are also, lawyer has got a duty to see that they will not accompany the lawyer for the purpose of mediation centers. Once the party comes, and there is a lawyer already appearing for the other party, or there is already a lawyer who has already sent a notice or something like that, then have a talk with the lawyer. Whether there is a possibility of dispute resolution can be done out of court. Once such an agreement has been entered into between the lawyers with the consent of the parties, then even without going to the court, they can adopt either arbitration is already there in the agreement. Most of the agreement, the arbitration clause is there. Even the mid-arbitration was also introduced in the new 2019 amendment, where mediation can be possible in arbitration also. Before going to the arbitrator into the dispute, he himself can mediate, or he can refer to an institutional mechanism, the mediation center for the purpose of mediation. Once the parties settle it, he can make an award on this agreements. But in a private mediation, because as far as court annex mediation is concerned, there is no difficulty, because once it comes to the court peruses the agreement and find out whether there is a flaw in the agreement or not. Once the flaw is found out and it is been sent back and it is corrected, normally applying Order 23 of Code of Civil Procedure, a compromise decree will be passed. Once a compromise decree is passed, enter the matter, no appeal will lie against that. Only on the ground if you are not a party to, if you have been fraudulently introduced for that purpose. Otherwise, it's not there. So what I am telling all those things is, just like I'm telling a story that you can bring the horse to the water, you cannot make the horse to drink. So this is an avenue that has been, a new avenue that has been given to you for your satisfaction and your benefit. It is for you to use it. How you use it is in your court. Use it in a better way so that Nirnaya can have success in the way in which they thought. Thank you very much for giving me the opportunity. Thank you.
We have come to the end of the session as well as the program. I thank everyone for the gracious presence and their wholehearted participation. Once again, thank you one and all. I have arranged tea for you at the end of this banquet hall. Kindly join us for tea.